दोस्तों नमस्कार। आज हम लोग आर्टिकल 22 ऑफ कॉन्स्टिट्यूशन के बारे में डिस्कस करने जा रहे हैं। आशा है ये वीडियो आपको अच्छा लगेगा। तो नमस्ते। क्या हाल है गर्मी के?
हालत खराब है सर।
वेस्ट कोस्ट में तो शायद तूफान आ रहा है, उधर गुजरात के साइड में
हम्म।
अरेबियन सी से।
इस तरफ तो कुछ नहीं।
और क्या क्या कोर्ट में आज?
कोर्ट में तो जो था वो तो मतलब अभी तो कोर्ट ये इधर तो वैकेशन था, मैं वैकेशन कोर्ट में जा रहा था और जो लोअर कोर्ट में दो चार केसेस था वो कर रहा था मैं। अभी तो हाई कोर्ट खुल गया, लेकिन सवाल ये है कि अभी इधर माता जी बीमार हैं, उधर सास बीमार है, बहुत प्रॉब्लम में हूँ। वाइफ जा रही है, जब जरूरत पड़ रहा है तब जा रहा हूँ मैं, बड़ा मुश्किल में हूँ मैं।
सही बात। तो अभी भाभी घर में
देखिए,
है, वहां गई हुई उनके पास?
नहीं नहीं, तो अभी अभी तो घर में है।
अच्छा अच्छा अच्छा।
अभी तो घर में है, लेकिन मतलब मैं भेज देता हूँ।
हम्म।
मैं जब नहीं जा पाता हूँ, एक्चुअली दोनों साथ ही निकलते हैं हम लोग, डेली दोनों साथ ही निकलते हैं।
अच्छा अच्छा अच्छा। तो कितना दूर रहती हैं वो?
कौन? हम लोग तो
आपकी?
एक ही साथ रहते हैं। माता जी थोड़ा सा मतलब दूर है, गांव के तरफ है,
अच्छा। नहीं, उनके बारे में पूछ रहा था तो
थोड़ा
गाँव
सा
की
दूर
तरफ।
है।
अच्छा।
नहीं, उनको ले आऊंगा मैं ले आऊंगा यहाँ, वहाँ नहीं रख पाऊंगा क्योंकि उस तरह देखिए यहाँ से कम्यूट करना मेरे लिए पॉसिबल नहीं होगा। उनको
हुँ।
यहीं लाना होगा मेरे यहाँ। अच्छा लगे बुरा लगे जो भी लगे, उनको यहीं लाना होगा, नहीं तो मैं संभाल नहीं पा रहा हूँ। मैं खुद बीमार पड़ रहा हूँ इससे। कितना दौड़ूं मैं।
हुँ।
क्योंकि हर संडे को जाना पड़ता है उनके यहाँ।
हुँ।
कल भी तो गया था मैं। कभी कभी सैटरडे को जाता हूँ, मंडे को वापस आता हूँ। अब वहाँ आदमी है, लेकिन उनका उम्र हो गया ना।
ऐसे ही है भाई, ये तो न्यूक्लियस फैमिली में बड़ा तमाशा है, तो क्या बोलें। ये रुचिका महापात्रा का फिर ये आर्टिकल है उनका ही, पता नहीं क्या लिखती हैं, देखें पढ़ते हैं क्या करते हैं ये लोग।
देखें क्या है।
मैं सोच रहा था इसमें 2-4 अपने भी जजमेंट दिखा देता हूँ। मेरे हाई कोर्ट का जजमेंट है ना 22/5 पे,
जी जी जी।
पहले पढ़ लेते हैं, देखेंगे क्या होता है। ये है भाई, देख लो।
Now,
आर्टिकल
notes on
22 है।
Article 22 of the Indian Constitution by
रुचिका
Ruchika
महापात्रा।
Mahapatra, 6th of April 2023।
हुँ।
जी सर, शुरू करता हूँ सर।
हाँ।
Article 22 of the Indian Constitution pertains to the protection of a person's rights to personal liberty and safeguards against detention or arrest. ये क्या हो गया?
जस्ट अ मिनट।
Detention or arrest without proper legal procedure. This article is considered to be one of the fundamental rights guaranteed to citizens of India. Article 22 applies to both citizens and non-citizens and protects individuals in cases of arrest and detention in certain cases by providing certain important rights. The core object behind this clause is to ensure the personal liberty of individuals that the personal liberty of individuals is maintained by preventing arbitrary arrests and detention. These safeguards are, however, not applicable to enemy aliens, people arrested under preventive detention law. तो ये इम्पोर्टेंट ज़्यादा है। प्रिवेंटिव डिटेंशन लॉ में यदि कोई अरेस्ट होता है तो दिस आर्टिकल, द सेफगार्ड ऑफ दिस आर्टिकल विल नॉट बी एप्लीकेबल। basically it talks about arrest without proper legal procedure. Clauses under Article 22. Article 22(1) states that any person who is arrested and detained shall be informed of the grounds of such arrest and shall have the right to consult and be represented by a legal practitioner of their choice. This provision ensures that an arrested person is not kept in the dark about the reason for their arrest and has the right to legal assistance.
हाँ
The
मजूमदार
first
साहब
rights.
ये बताओ 21
Yes, sir.
22(1) जो है ये ऊपर ये बोल रही है पीपल अरेस्टेड अंडर प्रिवेंटिव डिटेंशन लॉ में एप्लीकेबल नहीं है, तो यहाँ तो है ना कि इवन पर्सन हु इज डिटेन अंडर एन एक्ट, चाहे वो एनएसए हो चाहे
If
वो,
the detention is arbitrary,
तो वहां पर भी तो लगता है ना ये कि उसको ग्राउंड बताने ही पड़ेंगे ना।
हाँ, तो आर्बिट्ररी डिटेंशन होने से तो फिर तो ये लागू होगा।
तो ये गलत लिख रहा है ना ऊपर ये
हाँ, ये गलत लिख रहा है, इसमें ये लिखना चाहिए था प्रोवाइडेड द डिटेंशन इज नॉट आर्बिट्ररी। गलत ही लिख रहा है, सही बोल रहे हैं। आर्टिकल 22(1) states that any person who is arrested and detained shall be informed of the grounds of such arrest and shall have the right to consult and be represented by a legal practitioner of their choice. This provision ensures that an arrested person is not kept in the dark about the reason for the arrest and has the right to legal assistance. The first right states that the person who has been arrested or detained needs to be informed of the grounds of such arrest or detention, thereby
डिटेंशन बोल रही है तो
और डिटेंशन,
डिटेंशन तो किधर
thereby
आएगा,
ensuring,
लॉ में ही आएगा ना।
हाँ तो गलत लिखा है फिर। Ensuring that the arrest detention is not arbitrary. In the case of Joginder Kumar versus State of UP, it was held that the detained person should know the cause of his detention and is entitled to let any third person know the location of his detention. The second right enables the arrested person, detinue, to get a chance to be represented by a legal practitioner of his choice. This right is applicable right from the moment a person has been arrested. This enables the arrested person to get a fair trial. The Supreme Court in Hussainara Khatun versus State of Bihar has held that the right to a speedy trial is a constitutional right.
Now let's pause for a moment. अभी जोगिंदर कुमार को पढ़ते हैं। जोगिंदर कुमार क्या है, केस क्या है?
यहाँ क्लिक करते हैं तो आ जाए,
वो नेक्स्ट विंडो दूसरा विंडो खुल रहा है। वेंकट चलैया का है, मोहन का है, एस आनंद साहब का है। अच्छा हाँ, मस्त जजमेंट है, मैं इसको शेयर करता हूँ।
जी सर।
क्या सिर्फ कॉन्स्टिट्यूशन के जो मतलब आर्टिकल को पढ़ के फायदा नहीं है ना, जजमेंट के हिसाब से थोड़ा सा समझा।
एप्लीकेबिलिटी, हाँ, द एप्लीकेबिलिटी इज इम्पोर्टेंट।
आया ना आगे? हाँ
हाँ जी, ये सुप्रीम कोर्ट में डायरेक्टली गया था।
जोगिंदर कुमार वर्सेस स्टेट ऑफ यूपी 5 अप्रैल को जजमेंट प्रोनाउंस हुआ है।
1994
साइटेशन है 1994 AIR 1349 एज यूजुअल 1994 इज द ईयर, AIR इज ऑल इंडिया रिपोर्टर 1349 पेज पे है ये, एंड इसके इक्विवेलेंट साइटेशन है 1994 सुप्रीम कोर्ट केसेस, ये जर्नल का नाम है, वॉल्यूम 4 260 पेज पे
जी।
आथर इसके वेंकट चलैया साहब हैं, जस्टिस वेंकट चलैया हैं। और ये देखो केस टाइटल है जोगिंदर कुमार वर्सेस, रिस्पोंडेंट इज स्टेट ऑफ यूपी, डेट ऑफ जजमेंट इज 25 अप्रैल 1994। बेंच है, देख लो 3 लोगों की है,
एस मोहन,
वेंकट चलैया
के अलावा
एस मोहन एंड एस आनंद। एस आनंद बिकेम चीफ जस्टिस आफ्टरवर्ड्स। ये और भी साइटेशन है इधर,
और साइटेशन मतलब सेम केस का जहाँ मतलब ये पब्लिश हुआ है वो उसका रेफरेंस दे रहा है।
हाँ मतलब ये इधर भी आया है, जेटी में भी आया है और स्केल में भी आया है। अब तो स्केल तो बहुत एब्सोल्यूट हो गया, तो कोई पढ़ता ही नहीं है इसको, ज्यादातर सब एससीसी पढ़ते हैं, एआईआर
SCC
पढ़ते
पढ़ते हैं।
हैं। हाँ,
पढ़ो
दिस इज,
उसको।
हाँ पढ़ो
This,
पढ़ो तुम
a
पढ़ो।
pe- this
एलएलबी
is a
एलएलबी
petition
से,
under. This is a petition under Article 32 of the Constitution of India. The petitioner is a young man of 28 years who has completed his LLB and has enrolled himself as an advocate. The senior superintendent of police, Ghaziabad,
दादा एक
the
मिनट एक
respondent
मिनट,
number 4.
दादा
Uh,
दादा एक मिनट एक मिनट, दादा,
जी जी
this petition is under Article 32. So Article 32 will be dealt by us afterwards, where you
जी
can directly go to
Supreme
Supreme
Court
Court, Supreme Court by
for
way of,
violation of
writ, for violation of
for fundamental rights.
fundamental right. Now, after completing your LLB, you have to enroll with the bar council of the concerned high court as an advocate. Then only you'll be called as advocate. Otherwise, you'll be simply LLB. So
Bar
advocate,
Council of the state, state bar council, basically.
हाँ, तो ये जरूरी है। ये लड़का जो है 28 साल का था, एलएलबी करने के बाद में इसने एनरोल किया था। आगे पढ़ो।
The
The
senior
senior,
superintendent of police, Ghaziabad, the respondent number 4, called the petitioner in his office for making inquiries in some case. The petitioner, on the 7th of January 1994, at about 10 o'clock, appeared personally along with his brothers, Shri Mangeram Chaudhary, Nahar Singh Yadav, Harinder Singh, Tewatia, Amar Singh, and others before the respondent number 4. The respondent number 4 kept the petitioner in his custody. When the brother of the petitioner made enquiries about the petitioner, he was told that the petitioner will be set free in the evening after. On the 7th of January 1994, at about 12:55 p.m., the brother of the petitioner, being apprehensive of the intentions of the respondent number 4, sent a telegram to the Chief Minister of UP apprehending his brother's implication in some criminal case and also further apprehending the petitioner being shot dead in a fake encounter. In spite of frequent enquiries, the whereabouts of the petitioner could not be located. On the evening of 7th of January 1994, it came to be known that the petitioner had been detained in illegal custody of the fifth respondent, that is the station house officer, police station Mussoorie.
एक मिनट,
On
टाइम को
8th
कुछ गड़बड़ लगता है। 7th morning at 10 o'clock, he went to the police station on the call of the SP, and then ये क्या बोल रहे हैं, दोपहर को ना 12:40 to
12:55
को
p.m.
उसने चीफ मिनिस्टर को टेलीग्राम भेज दिया। अच्छा ठीक है। और शाम को क्या बोला कि नॉन
SHO के पास है।
अच्छा,
SHO के पास है, मुसौरी।
अच्छा,
कहाँ गाजियाबाद, कहाँ मुसौरी।
ये पुलिस स्टेशन मसूरी। ओके, ये
हाँ,
कहाँ कैसे पहुंच गया वहां तक ये बंदा?
ले गया उसको। और
ये
क्या,
कुछ हो
मैं
सकता है,
कल ही बोल रहा था ना।
मसूरी करके पुलिस स्टेशन होगा, ये सब हो सकता है। ये
अच्छा,
देहरादून के
हाँ
पास
हाँ हाँ, देहरादून वो मुसौरी नहीं है। हाँ, ये गाजियाबाद के पास कोई गांव होगा उस तरह का।
दैट वाज माय कंफ्यूजन कि इतनी देर में कैसे पहुंच सकता है।
हाँ, इसीलिए यही है। On 8th of January 1994, it was informed that the fifth respondent was keeping the petitioner, that means SHO, in detention to make further inquiries in some case. So far, the petitioner has not been produced before the magistrate concerned. Instead, the fifth respondent directed the relatives of the petitioner to approach the fourth respondent, that is the SSP Ghaziabad, for release of the
मसूरी
petitioner.
is under Ghaziabad district. Okay.
हाँ हाँ, तो ये दूसरा मुसौरी है। On 9th of January 1994 in the evening, when the brother of the petitioner, along with relatives, went to PS Mussoorie to inquire about the well-being of his brother, it was found that the petitioner had been taken to some undisclosed destination. Under these circumstances, the present petitioner has been preferred for the release of Joginder Kumar, the petitioner herein. This court on 11th of January.
दादा एक मिनट,
जी जी,
दिल्ली के आसपास में रहने का ये फायदा होता है, डायरेक्टली आप सुप्रीम कोर्ट में चले गए।
सुप्रीम कोर्ट जा सकते हैं।
और दूर का होता था तो वो सोचता भी नहीं था, तो हाई कोर्ट में घूमता रहता था।
जी। This court on the 11th of January 1994 ordered notice to the state of UP as well as the SSP Ghaziabad. The said senior superintendent of police, Ghaziabad, along with the petitioner, appeared before this court on 14th of January 1994. According to him, the petitioner has been released. The question as to why the petitioner was detained for a period of 5 days, he would submit, matlab SSP would submit that the petitioner was not in detention at all. His help was taken for detecting some cases relating to abduction, and the petitioner was helpful in cooperating with the police. Therefore, there is no question of detaining him. Though, as on today, the relief in habeas corpus petition cannot be granted, yet this court cannot put an end to the writ petition on this score. Where was the need to detain the petitioner for 5 days if really the petitioner was not in detention? Why was not this court informed? Are some questions which remain unanswered. If really there was a detention for 5 days, for what reason was he detained? These matters require to be inquired into. Therefore, we direct the learned district judge Ghaziabad to make a detailed inquiry and submit his report within 4 weeks from the date of receipt of this order. The horizon of human rights is expanding. At the same time, the crime rate is also increasing. Of late, this court has been receiving complaints about violation of human rights because of indiscriminate arrests. How are we to strike a balance between the two? A realistic approach should be made in this direction. The law of arrest is one of balancing individual rights, liberties, and privileges. On the other hand, individual duties, obligations, and responsibilities of weighing and balancing the rights, liberties, and privileges of the single individual and those of the individuals collectively, of simply deciding what is wanted and where to put the weight and the emphasis, of deciding which comes first, the criminal or society, the law violator or the law abider, or meeting the challenge which Mr. Justice Cardozo so forthrightly met when he wrestled with a similar task of balancing individual rights against society's rights, and wisely held that the exclusion rule was bad law, that society came first and the criminal should not go free because the constable blundered. In People versus Defoe, Justice Cardozo observed, the American Supreme Court cover. The
Mm-hmm.
question is whether protection for the individual would not be gained at a disproportionate loss of protection for society. On one side is the social need that crime shall be repressed, on the other, the social need that law shall not be flouted by the insolence of office. There are dangers in any choice. The rule of Acclam's case, People versus Adams, strikes a balance between opposing interests. We must hold it to be the law until those organs of government by which a change of public policy is normally effected shall give notice to the courts the change has come to pass. To the same effect, in the statement by the learned hand in Fred Ray 3. The protection of the individual from oppression and abuse by the police and other enforcing officers is indeed a major interest in a free society, but so is the effective prosecution of crime, an interest which at times seems to be forgotten. Perfection is impossible, like other human institutions. Criminal proceedings must be a compromise. The quality of a nation's civilization can be largely measured by the methods it uses in the enforcement of criminal law. अब ये दिस कोर्ट मतलब सुप्रीम कोर्ट बोल रहा है दिस कोर्ट इन नंदिनी सतपति वर्सेस पीएल दानी here page 1032 quoting Louis Myers stated SEC page for 433 para 15 the paradox has been put sharply by Louis Myers to strike the balance between the needs of law enforcement on the one hand and the protection of citizens from oppression and injustice at the hands of the law enforcement machinery on the other is a perennial problem of statecraft. The pendulum over the years has swung to the right. Right matlab law enforcing machinery. Again, in AIR para 21, page 1033, it was observed. SCC page 436, para 23. We have earlier spoken of the conflicting claims requiring reconciliation. Speaking pragmatically, there exists a rivalry between societal interests in effecting crime detention and constitutional rights which accused individuals possess. Emphasis must shift depending on circumstances and balancing these interests, as has been happening in these cases of
These cases, okay.
न्यूयॉर्क और क्या क्या मतलब और एससीसी भी दिया गया है इसमें या 1978 एससी फलाना अमेरिका. Since Miranda, there has been a retreat from stress on protection of the accused and gravitation towards society's interests in convicting lawbreakers. Currently, the trend in the American jurisdiction, according to legal journals, is that respect for the constitutional principles is eroded when they leave their proper bounds to interfere with the legitimate interests of the society in enforcement of its laws. Couch versus United States. Our constitutional perspective has therefore to be relative and cannot afford to be absolutist, especially when torture, technology, crime escalation, and other social variables affect the application of principles in producing humane justice. The National Police Commission, in its third report, referring to the quality of arrests made by the police in India, mentioned power of arrest as one of the chief sources of corruption in the police. The report suggested that by and large, nearly 60% of the arrests were either unnecessary or unjustified, and that such unjustified police action accounted for 43.2% of the expenditure of the jails. The Commission's third report at page 31 observed thus: it is obvious that a major portion of the arrests were connected with very minor prosecution and cannot therefore be regarded as quite necessary from the point of view of crime prevention. Continued detention in jail of the persons so arrested has also meant avoidable expenditure on their maintenance. In the above period, it was estimated that 43.2% of the expenditure in the connected jails was over such prisoners only who, in the ultimate analysis, need not have been arrested at all. As on today, arrests with or without warrant, depending upon the circumstances of a particular case, is governed by the Code of Criminal Procedure. Whenever a public servant is arrested, that matter should be intimated to the superior officers, if possible, before the arrest, and in any case, immediately after the arrest. In cases of members of the armed forces, army, navy, or air force, intimation should be sent to the officer commanding the unit to which the member belongs. It should be done immediately after the arrest is effected. Under Rule 229 of the Procedure and Conduct of Business in Lok Sabha, when a member is arrested on a criminal charge or is detained under an executive order of the magistrate, the executive authority must inform without delay such facts to the Speaker. As soon as any arrest, detention, conviction, or release is effected, intimation should invariably be sent to the government concerned, concurrently with the intimation sent to the Speaker or the Chairman of the Legislative Assembly or the Council, Lok Sabha or Rajya Sabha. This should be sent through telegrams or by post, and the intimation should not be on the ground of holiday. Miranda versus Arizona, US Supreme Court का reference है इसमें. With regard to the apprehension of juvenile offenders, Section 58 of the Code of Criminal Procedure lays down as under: officers in charge of police stations shall report to the district magistrate, or if he so directs, to the subdivisional magistrate, the cases of all persons arrested without warrant within the limits of the respective stations, whether such persons have to be admitted to bail or otherwise. Section 19A of the Children's Act makes the following provision: the parent or guardian of the child, if he can be found of such arrest, and direct him to be present at the children's court before which the child will appear. In England, the police power of arrest, detention, and interrogation have been streamlined by the Police and Criminal Evidence Act 1984, based on the report of Sir Cyril Phillips Committee, report of a Royal Commission on Criminal Procedure, Command Papers 8092 1981 1. It is worth quoting the following passage from Police Powers and Accountability by John L. Lambert, page 93. More recently, the Royal Commission on Criminal Procedure recognized that there is a critically important relationship between the police and the public in the detention and investigation of crime, and suggested that public confidence in police powers required that these conform to three principal standards, namely fairness, openness, and workability. Emphasis applied. The Royal Commission suggested restrictions on the power of arrest on the basis of necessity of principle. The two main objectives of this principle are that police can exercise powers only in those cases in which it was genuinely necessary to enable them to execute their duty, to prevent the commission of offences, to investigate crime. The Royal Commission was of the view that such restrictions would diminish the use of arrest and produce more uniform use of powers. The Royal Commission report on criminal procedure, Sir Cyril Phillips at page 45 said, "We recommend that detention upon arrest for an offence should continue only on one or more of the following criteria: A. The person's unwillingness to identify himself so that a summons may be served upon him. B. The need to prevent the continuation or repetition of that offence. C. The need to protect the arrested person himself or other persons or property. D. The need to secure or preserve evidence of or relating to that offence or to obtain such evidence from the suspect by questioning him. And E. The likelihood of the person failing to appear at court to answer any charges made against him." The Royal Commission in the above said report at page 46 also suggested, to help to reduce the use of arrest, we should we would also propose the introduction here of a scheme that is used in Ontario, enabling a police officer to issue what is called an appearance notice. That procedure can be used to obtain attendance at the police station without resorting to arrest, provided a power to arrest exists, for example, to be fingerprinted or to participate in an identification parade. It would be extended to attendance for interview at the time convenient both to the suspect and to the police officer investigating the case. In India, the third report of the National Police Commission at page 32 also suggested an arrest during the investigation of the cognizable case may be considered justified in one or other of the following circumstances. Number one, the case involves a grave offense like murder, dacoity, robbery, rape, etc., and it is necessary to arrest the accused and bring his movements under restraint to infuse confidence among the terror-stricken victims. Number two, the accused is likely to abscond and evade the processes of law. 3. The accused is given to violent behavior and is likely to commit further offences unless his movements are brought under restraint. 4. The accused is a habitual offender and unless kept in custody is likely to commit similar offences again. It
So
would be
these are the four
desirable.
conditions for arrest mainly.
हाँ, हाँ,
अभी
in
जब
India.
मर्डर होता है तो पब्लिक को लगता है ना कि क्यों अरेस्ट कर लिया, इसलिए अरेस्ट कर लिया कि
जी जी
वो
if the
आदमी
case
पब्लिक में एक कॉन्फिडेंस हो जाए कि हाँ भाई ठीक है, इसको अरेस्ट कर लिया है तो दोबारा कुछ काम नहीं करेगा, और अगर वो हैबिचुअल ऑफेंडर है तो और दोबारा कुछ ना कर जाए वो, और उसका जो
restraint
सबसे बड़ी चीज ये है कि वो बाहर रहेगा तो अब कौन कर जाएगा ना,
हाँ एब्सकॉन्ड कर जाएगा या डराएगा धमकाएगा, मतलब
हाँ,
विटनेसेस को
और विटनेसेस को इन्फ्लुएंस
गायब
करेगा
कर
वो।
देगा. जी 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 It would be desirable to insist through departmental instructions that a police officer making an arrest should also record in the case diary the reasons for making the arrest, thereby clarifying its conformity to the specified guidelines. The above guidelines are merely the incidents of personal liberty guaranteed under Constitution of India. No arrest can be made because it is lawful for the police officer to do so. The existence of the power to arrest is one thing. The justification for exercise of it is quite another. The police officer must be able to justify the arrest apart from his power to do so. Arrest and detention in police lockup of a person can use incalculable harm to the reputation and self-esteem of a person. No arrest can be made in a routine manner on a mere allegation of commission of an offence made against a person. It would be prudent for a police officer, in the interest of protection of the constitutional rights of the citizen and perhaps in his own interest, that no arrest should be made without a reasonable satisfaction reached after some investigation as to the genuineness and bona fides of a complaint, and a reasonable belief both as to the person's complicity and even so as to the need to effect arrest. Denying a person of his liberty is a serious matter. The recommendations of the Police Commission merely reflect the constitutional non-commitants of the fundamental right to personal liberty and freedom. A person is not liable to arrest merely on the suspicion of complicity in an offense. There must be some reasonable justification, in the opinion of the officer, affecting the arrest. The such arrest is necessary and justified. Except in heinous offences, an arrest must be avoided. If a police officer issues notice to a person to attend the station house and not to leave the station house without permission to do so, then there is the right to have someone informed. The right of the arrested person upon request to have someone informed and to consult privately with a lawyer was recognized by Section 56, subsection 1 of the Police and Criminal Evidence Act 1984 in England. Civil actions against the police, Richard Clayton and Hugh Tomlinson, page 313. That section provides where a person has been arrested and is being held in custody in a police station or other premises, he shall be entitled, if he so requests, to have a friend or relative or other person who is known to him, who is likely to take an interest in his welfare, told as soon as it is practicable, except to the extent that delay is permitted by this section, that he has been arrested and is being detained there. These rights are inherent in Article 21 and 22(1) of the Constitution and required to be recognized and scrupulously protected. For effective enforcement of these fundamental rights, we issue the following requirements. मतलब कोर्ट बोल रहा है, we issue the following requirements. Number one, an arrested person being held in custody is entitled, if he so requests, to have one friend, relative, or other person who is known to him or likely to take an interest in his welfare told as far as is practicable that he has been arrested and where he is being detained. Number two, the police officer shall inform the arrested person when he is brought to the police station of this right. 3. An entry shall be made in the diary as to who was informed of the arrest. These protections from power must be held to flow from Articles 21 and 22(1) and enforced strictly. It shall be the duty of the magistrate before whom the arrested person is produced to satisfy himself that these requirements have been complied with. The above requirements shall be followed in all cases of arrest till legal provisions are made in this behalf. These requirements shall be in addition to the rights of the arrested person found in various police manuals. These requirements are not exhaustive. The Directors General of Police of all the states in India shall issue necessary instructions requiring the observance of these requirements. In addition, departmental instructions shall also be issued that a police officer making an arrest should also record in the case diary the reasons for making the arrest.
कितना अच्छा जजमेंट है ना ये।
हाँ हाँ, इसमें पूरा इसी के ऊपर बेस करके अभी का जो कानून बन रहा है सब इसी के ऊपर बेस करके बना है। मतलब ये पहला जजमेंट था जिसमें ये पूरा क्लियरली बता दिया गया कि क्या क्या करना चाहिए।
प्रेम जी साहब दिखाई दे रहे हैं यहाँ पर, लिंक भेज दो क्या?
हाँ हाँ, दे दीजिए, कोई दिक्कत नहीं।
प्रेम जी को मैं, अच्छा ठीक है, दे देता हूँ, अगर किसी को और को आना तो वो भी आ जाएगा, नो प्रॉब्लम।
ठीक है, कोई बात नहीं।
तो ये तो चीज इम्पोर्टेंट है पब्लिक के लिए।
हाँ, तो ये आर्टिकल 22 सब आर्टिकल 2 में आता हूँ। हम लोग तो इसको तो कवर कर लिए, जोगिंदर सिंह वाला।
हाँ हाँ हाँ, नीचे द सेकंड राइट
लीगल प्रैक्टिस। अच्छा, तो सेकंड राइट enables the arrested person detained to get a chance।
ये क्या है हुसैन आरा, ये प्रिवेंटिव डिटेंशन है क्या? एक मिनट रुको, ये देखते हैं क्या है।
ठीक है।
हुसैन आरा खातून होम सिक्योरिटी स्टेट ऑफ 1979 है ये, पीएन भगवती।
Right to be represented by a legal practitioner of his choice.
Held the procedure with the person may be deprived of his life liberty should be reasonable fair। अरे ये जरूरी है, दिखाते हैं इसको, थोड़ा लेट हो जाएगा, चलता है।
नहीं ठीक है, फिर उसको पढ़ लेते हैं।
कुछ लोग अपना YouTube में बनाते हैं लेकिन वो शॉर्ट में मार देते हैं कि आप इसको पढ़ लीजिए, वो पढ़ लीजिए, तुमको समझ में आएगा नहीं, पब्लिक को तो क्या करेंगे पढ़ करके। देखो ये है
जी जी,
हुसैन आरा खातून वर्सेस एंड अदर्स है। और भी इसमें कई लोग हैं। Okay.
PN Bhagwati.
1979 AIR 1369, 1979 SCR Supreme Court case reporter
Reporter, page,
3, volume
volume 3,
3,
page
532.
532.
Date of
Home
judgment is
Secretary, State of Bihar,
hmm,
the respondent,
hmm.
Desai, DA
DPM
Desai
में
साहब
दो ही लोग हैं,
हाँ
भगवती एंड
हाँ
देसाई।
हम्म,
ये देसाई कौन है मालूम है? अशोक देसाई है ना, जो बॉम्बे हाई कोर्ट का सीनियर एडवोकेट,
हाँ हाँ
उसका बाप है ये।
अच्छा, उसका पिताजी, अच्छा।
हम्म। बाकी ये इक्विवेलेंट साइटेशन इधर भी है, और जगह भी रिपोर्ट
हाँ
हुआ है, दो
सारा है,
जगह।
सारा रिपोर्ट हुआ है।
Administration of justice, speedy trial, fundamental right of accused, constitutional obligation of state, Constitution of India,
फ्री लीगल सर्विसेज
32, free legal services
टू
to poor।
पुअर।
हाँ, ये है, इसीलिए हाई कोर्ट बोलता है भाई ठीक है, इनको लीगल सर्विस दे दो। हर हाई कोर्ट में एक लीगल सर्विस सेल होता है।
जी जी।
एट द रिज्यूम हियरिंग ऑफ द पिटीशन फॉर रिलीज ऑफ अंडर ट्रायल इन द स्टेट ऑफ, वैसे यही है जो सारे के सारे अपना जो प्रेस्क्राइब पीरियड पनिशमेंट था उसके ऊपर चले गए थे, उनके लिए है ना सर ये, वही वाला है। हेल्ड पढ़ो तो, हेल्ड
Held, the procedure under which a person may be deprived of his life or liberty should be reasonable, fair, and just. Free legal services to the poor and the needy is an essential element of any reasonable, fair, and just procedure. A prisoner who is to seek his liberation through the court's process should have legal services available to him. उसी के आधार पर ये किया गया। उसके बाद मानेगा गांधी रही है, बाकी रेफरेंस दिए हैं सब। नीचे आता है ना, आर्टिकल 39A also emphasizes that free legal service, नीचे, that free legal service is an inalienable element of reasonable, fair, and just procedure, for without it a person suffering from economic or other disabilities would be deprived of the opportunity for securing justice. The right to free legal service is therefore clearly an essential ingredient of reasonable, fair, and just procedure for a person accused of an offense, and it must be held implicit in the guarantee of Article 21. This is a constitutional right of every accused person who is unable to engage a lawyer and secure legal services on account of reasons such as poverty, indigence, an incommunicado situation, and the state is under a mandate to provide a lawyer to the accused person if the circumstances of the case and the needs of justice so require, provided, of course, the accused person does not object to the provisions of such lawyer. और
इसीलिए
ये
अजमल
मैं
कसाब को एडवोकेट दिया गया था।
हाँ, और नहीं, वैसे तो और लोगों को भी देते हैं, उसको तो स्पेशली मतलब दिया गया था। द पुअर इन द
पब्लिक के दिमाग
कॉन्टैक्ट
में
विद
एक मिसकंसेप्शन है ना कि वो क्रिमिनल है तो उसको तुम एडवोकेट क्यों दे रहे हो, ये क्यों कर रहे हो, वो क्यों कर रहे
में
हो।
देना पड़ेगा। ये हर देश में, हर डेमोक्रेटिक कंट्री में ये प्रोविजन है।
हाँ,
ये हम
हाँ।
लोग तो poor in their contact with the legal system have always been on the wrong side of the law. They have always come across law for the poor rather than law of the poor. The law is regarded by them as something mysterious and forbidding, always taking something away from them, and not as a positive and constructive social device for changing the socio-economic order and improving their life conditions by conferring rights and benefits on them. The result is that the legal system has lost its credibility for the weaker sections of the community. It is therefore necessary to inject equal justice into legality, and that can be done only by a dynamic and activist scheme of legal services. The urgent necessity of introducing a dynamic and comprehensive legal services program impressed upon the Government of India as also the state governments. That is not only a mandate of equal justice implicit in Article 14 and right to life and liberty conferred by Article 21, but also the compulsion of the constitutional directive embodied in Article 39A. The state cannot avoid its constitutional obligations to provide speedy trial to the accused by pleading financial or administrative inability. The state is under a constitutional mandate to ensure speedy trial, and whatever is necessary for this purpose has to be done by the state. It is also the constitutional obligation of this court, as the guardian of the fundamental rights of the people, as a sentinel on the V5, to enforce the fundamental right of the accused to speedy trial by issuing necessary directions to the state, which may include taking a positive action such as augmenting and strengthening the investigative machinery, setting up new courts, building new courthouses, appointment of additional judges, and other measures calculated to ensure speedy trial. The courts in the United States have adopted a dynamic and constructive role in regard to prison reform by utilizing the activist magnitude of the Eighth Amendment. The courts have ordered substantial improvements to be made in a variety of archaic prisons and jails through its decisions. ये सारे डिसीजन दिए हुए हैं यूनाइटेड
सेवन
स्टेट्स का.
सेवन
The
पढ़ो
power of
सेवन.
this court the power of this court in protection of the constitutional rights are of the widest amplitude, and this court should adopt an activist approach and issue to the state directions which may involve taking a positive action with a view to securing enforcement of the fundamental right to speedy trial. But in order to enable the court to discharge this constitutional obligation, it is necessary that the court should have the requisite information bearing on the problem. Directed that A. On the next remand dates, when the under trials are produced before the magistrates or the session courts, the state government should provide them with a lawyer at its own cost for the purpose of making an application for bail and opposing remand, provided that no objection is raised to such a lawyer on their behalf. B. The state government and High Court is to furnish particulars as to the location of the courts of magistrates and courts of sessions in the state of Bihar, together with the total number of cases pending in each of these courts as on 31st of December 1978, giving year-wise breakup of such pending cases and also explaining why it has not been possible to dispose of such of those cases as have been pending for more than 6 months.
दादा,
मोटा मोटी यही है. जी सर.
इसका पीएन भगवती साहब का जो मूड है ना, कैसा चेंज हो रहा है. जब इमरजेंसी थी तो कुछ अलग तरीके से बोलते थे,
बिल्कुल हम लोग. हाँ.
और इमरजेंसी हट गई तो उसके बाद में अलग तरीके से बोलने लगे.
ये कलेक्टिवली जितने अंडर ट्रायल प्रिजनर्स थे उनके ऊपर ये केस हुआ है.
यहाँ पे क्या बोल रहा है?
There are several under trial prisoners who are charged with offences which are bailable but who are still in jail, presumably because no application for bail has been made on their behalf, and being too poor, they are unable to furnish bail. It is not uncommon to find. मेन चीज यही है.
ठीक है, फिनिश. इसके बाद इसको हमने क्रक्स पढ़ लिया इसका. अब आ जाते हैं
पैराग्राफ हम लोग लास्ट में पढ़े, वही इम्पोर्टेंट है.
मेन आर्टिकल पे जाते हैं. हाँ
जी सर. Article 22(2) states that any person who is arrested and detained must be produced before the nearest magistrate within 24 hours of their arrest, including the time required for transportation. This provision is aimed at preventing arbitrary detention and ensuring that the detained person is produced before a judicial authority within a reasonable time. This clause also finds support in Section 56 of the Code of Criminal Procedure and Section 167 of the Code of Criminal Procedure. This clause also states that no person who is arrested should be detained for more than 24 hours without being produced before a magistrate or judicial authority and getting the detention authorized as mentioned in Section 167. These 24 hours are not inclusive of the time of travel from the place of arrest to the magistrate's court.
जस्ट अ मिनट, दादा क्लैरिफाई
हाँ
करो
हाँ
थोड़ा सा, मेरा डाउट है एक, ये जो
हम्म
बोल रहा है यहाँ
नॉट
पे,
इंक्लूसिव ऑफ द टाइम बोल
नहीं, हु इज अरेस्टेड, who the clause also state that no person who is arrested should be detained for more than, ठीक है, तो यहाँ पर क्या हो रहा है, अरेस्ट इज इम्पोर्टेंट,
हाँ अरेस्ट तो इम्पोर्टेंट है फॉर्मल अरेस्ट
टेकिंग टेकिंग
फॉर्मल अरेस्ट
टेकिंग मतलब asking somebody
कस्टडी
to police station or picking someone from somewhere
and
and
then questioning
then
him.
taking him to the police station for inquiry, this thing and that thing, that
That is not arrest.
that's not turned about to arrest. Arrest means
Correct,
the
correct.
moment a police officer deprive a person of his
Of his liberty.
liberty and he gives a thing that you are arrested at so and so time. He makes the entry in diary also, and he
Entry in
gives
the
the arresting
general
also.
diary and
That then that time is material. So it should not be confused that a person has been picked up from somewhere, so he is arrested. No, he may have been taken for inquiry, investigation purposes, this thing and that thing. But the moment a person is arrested, then it is obligation on the part of the authorities, whether police or whosoever it is, that that person has to be produced before a magistrate of that jurisdiction within 24 hours of his arrest.
at the same time, sir, going back to what we had read earlier, ये भी clarify करना चाहिए कि a person on the garb of being questioned cannot be kept for 2 days in a police station. ऐसे ही.
That is there.
हाँ हाँ हाँ.
वहां तो ये है कि then he मतलब the relative of person should be informed ना that what purpose he has been
Informed.
taken. ये तो नहीं कि तुम इसको डाक में रख दोगे, उसका फंडामेंटल राइट आपने कर्टेल कर दिया ना, फिर
जी जी.
ना बात करने दे रहे हो, ना खाना खाने दे रहे हो, अपनी मर्जी से खाना खिला रहे हो, क्या मतलब है?
Article 22(3) is an exception to clauses 1 and 2 of Article 22 and states that none of the rights mentioned in clause 1 and 2 of the article would be applicable for a person who is deemed to be an enemy alien and anybody who is arrested or detained under the law providing for preventive detention.
ग्राउंड
अब फिर
ग्राउंड तो
बोल रहा
बताना
है
पड़ता है, ग्राउंड तो बताना ही पड़ेगा उसको.
हाँ हाँ हाँ. Article 22(4) states that no law providing for preventive detention shall be made except in cases specified in Article 22(3) and 4. Preventive detention refers to the detention of a person to prevent that person from committing a crime in future. This provision ensures that preventive detention is not misused by the government to suppress dissent or opposition. मतलब the basic purpose is to prevent the detain from committing a crime in future. That is the basic objective. Article 22(5) states that when a person is detained in pursuance of an order made under any law providing for preventive detention, the authority making the order shall as soon as may be
यहाँ है वो. ओके 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 ओके, इधर है. ओके, ग्राउंड यहाँ पे.
communicate to such person the grounds on which the order has been made and shall afford him the earliest opportunity of making a representation against the order. Reply तो मांगता है, DRI भी मांगता है. DRI भी अरेस्ट करने के बाद मांगता है, पकड़ा देता कागज, बोलता है इसका रिप्लाई दो. Opportunity of making a representation against the order. Parliament may by law prescribe the circumstances under which a person may be detained for a period longer than 3 months under any law providing for preventive detention without obtaining the opinion of an advisory board.
जम्मू कश्मीर भी
हाँ. Article 22(6) states that Clause 5 doesn't require the authority issuing such order to disclose information that it deems to be contrary to popular opinion and interest. Contrary to popular opinion and interest. Article 22(7) states that the Parliament may prescribe by law a. the circumstances and classes of cases in which detention of persons for more than 3 months of detention time while under the law require preventive detention without trying to obtain the opinion of an advisory board in accordance with the provisions of Clause 4 of Subclause A. B. The maximum period of detention under any law providing for preventive detention in any class or classes of cases. C. The process that an advisory board must use when conducting an investigation under Clause 4, Subclause A.
दादा
अच्छा फिर वो जी
दादा इसके मतलब ये हुआ, let the viewer should be clear in the mind that there are two types of law. One is punitive and another is preventive.
preventive.
One is punitive. Punitive in the sense if you commit a crime,
And
then
you're
you'll be
punished for
charged
that.
under IPC or whatever it is,
Mhm.
and then the legal process will start. So, if the punishment is granted for that, then that law is punitive in nature.
Correct, sir.
Prevention means it is not by the court; it is executive order.
Executive order to prevent that person from committing anything
Engaging in the
which is
same activity in future.
future.
So it is a sort of a preponderance that you are likely to commit the same crime again. So you are being prevented from committing that crime for at least 1 year, 2 years, or whatever it is, depending on the state and exigencies, whatever it is.
And the circumstances of that
So
particular situation.
22, 22, Article 22 deals with punitive and preventive laws.
Correct, sir.
Viewer should be very much careful that this is very important article, and every law student should have note of this. ये है क्या
And
चीज,
particularly
ये
the
सवाल
rights
पूछ
also.
सकते हैं कि what is the
The
difference
rights
between
which are
punitive and
available.
preventive law. हाँ, गोपालन केस पढ़ लिया हम लोगों ने, मनका गांधी पढ़ लिया,
जी पढ़ लिया.
ये पढ़ो अनवर अली सरकार क्या बोल रहे हैं.
In the case of State of West Bengal versus Anwar Ali Sarkar, the Supreme Court held that the right to legal representation was a fundamental right, and the state was obligated to provide legal aid to a person who could not afford it.
अच्छा
This
जी, तो ये वही
decision
है,
was
वो जनरल वाला
significant
ही हुआ ना
in
ये.
ensuring the right to legal representation was available to all, regardless of their financial means. In the case of D.K. Basu versus State of West Bengal, the Supreme Court
ये
issued
तो
guidelines for
हर
the
एक
arrest and
लॉ स्टूडेंट को ये बिल्कुल रख लेना
हाँ
चाहिए.
हाँ
राम जैसे हनुमान चालीसा जेब में रखते हैं, भगवत गीता
ये तो बहुत इम्पोर्टेंट है.
हमेशा पूछता है इसको, ये डेली लाइफ में भी यूज होता है.
Guidelines for arrest and detention, including the requirement that the arresting officer must inform the person of the right to legal representation and that a relative or friend of the person must be informed of the arrest. This decision was significant in ensuring that the arrest and detention of a person was conducted in a humane and fair manner.
अच्छा, इसमें एक चीज और बता देता हूं मैं. डीके बसु में अगर इसको पढ़ेंगे 8-10 इसके गाइडलाइंस हैं, उसमें एक ये भी है, द पर्सन हु इज अरेस्टिंग ही शुड डिस्प्ले हिज नेम इन द नेम प्लेट. ये नहीं कि उसका नेम प्लेट रख के फाड़ के फेंक दे, वो कर दे, सो दैट
नहीं
द
आजकल
पर्सन हु इज अरेस्टेड should know that who is
should know.
that idiot who is taking my fundamental right.
Correct.
Essential component of individual right and protect against liberty, arbitrary arrest and
पढ़ लो
detention.
इसको.
हाँ, पढ़ दो.
Article 22 of the Indian Constitution is an essential component of individual rights and protects against arbitrary arrest and detention. The provision for legal representation and the right to be produced before a magistrate within a reasonable time ensures that the detained person is not left in the dark and has access to legal assistance. The provision for restriction on preventive detention ensures that a person is kept in custody indefinitely, is not kept in custody indefinitely, and that preventive detention is not misused by the government. The various court decisions have helped to clarify and strengthen the protection of individual rights under Article 22. बोल रहे important questions.
नहीं, वो नहीं, वो छोड़ दो, वो सब ऐसे ही है.
ये important है. हाँ, जो पढ़े हैं ये ज्यादा important है. The right to be informed,
ये
the right to
नहीं,
legal
ये
aid.
बात कर रहा है कि यहाँ पे क्या बोल रहा है वो. अरे वह परिषद
वो एग्जाम्पल दे रहा है ना.
हाँ, वो इसको नहीं. अभी मैं बॉम्बे हाई कोर्ट में जो मेरे जब केसेस थे उनके बारे में बताता हूँ, जो 22(5) में मैंने लड़े थे.
जी जी जी.
वो थोड़ा सा मतलब फॉर द इंटरेस्ट ऑफ पब्लिक 2 ही 3 केसेस थे. नॉर्मली मैं इस पे जाता नहीं हूँ रिप्रेजेंटेशन के ऊपर, लेकिन फिर भी
ये थोड़ा सा हटकर ही होंगे ना. नॉर्मल केस तो नहीं है।
क्या बात है, केस स्टेटस कहाँ है भाई? अरे कहाँ गया केस? कैसे हो गया इसका? जो अदर लिंक सर्विसेज, सर्विसेज में केस स्टेटस, ओके। केस स्टेटस में पार्टी वाइज, पार्टी वाइज यादव, यादव। अच्छा एक काम करता हूँ, मतलब लेट मी शो द कि कैसे हम लोग केस सर्च करते हैं बॉम्बे हाई कोर्ट की साइट में जाकर के। इसको मैं वही कर देता हूँ, लिंक शेयर कर देता हूँ।
हाँ दिखा दीजिए।
दैट इज बेटर। तो हिरन में जैसे लोगों को थोड़ा मालूम पड़ जाएगा ना केस कैसे सर्च करते हैं।
जी
तो वापस क्यों चला जाता है? देख रहे हैं ना हिरन में?
हाँ,
देख रहे हो ना?
नहीं है तो
सर मैं कुछ टाइप कर
दिखा।
रहा था, बोलिए ना।
नहीं, हम तुम्हारे को दिखा रहे हैं हम लोग केस कैसे सर्च करते हैं। अभी मैं बॉम्बे हाई कोर्ट की साइट पे जा रहा हूँ। बॉम्बे हाई कोर्ट में मुझे अपना केस सर्च करना है, तो कैसे हम लोग केस सर्च करते हैं। कलकत्ता हाई कोर्ट में जाओगे तो कैसे केस सर्च करोगे, वो मैं बताना चाहता हूँ।
ठीक है, मैं समझ गया। आप कंटिन्यू कीजिए, मैं म्यूट करता हूँ।
हाँ, ये बॉम्बे हाई कोर्ट का साइट है, वेबसाइट।
जी
अब इसमें लिखा हुआ है सर्विसेज, सर्विसेज में केस स्टेटस। केस स्टेटस में मुझे अपने क्लाइंट का नाम
केस
मालूम
नंबर।
है।
हाँ ये मतलब तरीके बहुत हैं।
हाँ
केस
नहीं,
नंबर यदि मालूम हो तो बढ़िया है, बता दीजिए।
हाँ
सब तरीके बहुत हैं।
नॉमिनल
पिटिशनर
नंबर नहीं
रिस्पॉन्डिंग से भी।
होता है लोगों को, नहीं जैसे याद आता है ना कि मेनका गांधी करके, तो मेनका गांधी में नंबर
हाँ हाँ, नाम डालने से भी आ जाएगा।
हाँ तो ये है।
अच्छा, एडवोकेट का नाम पता होने से वो भी आ
हाँ
सकता है।
उधर भी आ
एडवोकेट
जाता है, सब
वाइज,
कुछ आ जाता
पार्टी
है
वाइज,
हम्म, तो मैं पार्टी
सीएनआर
वाइज जा रहा
सीआईएन
हूँ।
नंबर वाइज, फाइलिंग नंबर वाइज, मतलब कई
पार्टी
ऑप्शंस हैं
में
इसमें।
मेरा जो क्लाइंट है उसका जो सरनेम है वो जादव है।
हाँ, यादव का जितना है सब आएगा इसमें।
अभी देखते
उस
हैं
साल का
इसमें।
जितना।
अभी
हाँ
इसमें हाँ, तो मैं फिर उसमें से निकालूंगा ना अपना वाला कौन सा है। क्रिमिनल केस हुआ,
हाँ, तो
ये देखो
आप हाँ, क्रिमिनल और
क्रिमिनल हो
ईयर
गया,
दीजिएगा।
जुडिशियल
हाँ
क्रिमिनल आ गया। एंड नाउ
हाँ,
ईयर,
अब
ईयर
ईयर
इज
दीजिए।
2013।
हम्म,
ठीक है।
बस। और
अब
ये
यहाँ पे आएगा
सिक्योरिटी कोड देना होगा।
कोड 5
एम
एम वाई
वाई ए
ए एस डी।
एस डी। एस डी है सर, डी। हाँ
हाँ डी 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 डी
ठीक
है।
है। हाँ डी। अब
अब
देखिए।
देखिए, ये इतने सारे जादू आए हैं, मुझे जैसे ही सबके सब आए हैं इसमें से अपना वाला देखना है कौन सा है। तो देखो यहाँ से शुरू हो रहा है, क्रिमिनल केसेस हैं सारे के सारे, इधर डब्ल्यू पी लिखा हुआ
हाँ
है।
जी,
हाँ? डब्ल्यू
रिट
ये सारे के
पिटिशन
सारे।
भी है।
अब
रिट पिटिशन भी है।
सर मैं एक प्रश्न को पूछना चाहूंगा।
बोलो
क्या
बोलो।
ये सभी केस रनिंग है या फिर इसका जजमेंट हो चुका है?
हो चुका है।
अच्छा, हो चुका है।
हाँ इतने सारे हैं
वो
ये।
भी एक आता है, डिस्पोज्ड ऑफ और पेंडिंग, वो भी एक आता है ऑप्शन।
हम्म, देख लो पूरे साल में कितने जादू हैं।
बहुत होंगे। ये तो कॉमन टाइटल है महाराष्ट्र में, जादव।
हाँ, ठीक है।
शो मोर और है।
हाँ अभी मैं पब्लिक को दिखाने के लिए कर रहा था।
जी
अब मैं
जी जी।
अपना केस देख लेता हूँ, क्या केस का नाम क्या था मेरा वाला। वो नंबर से मालूम पड़ जाएगा ना मेरे को। श्यामला जादव थी शायद वो, मुझे इतना याद है, उसकी मम्मी थी।
अच्छा, स्क्रॉल कीजिए सर धीरे धीरे।
नहीं नहीं, यहाँ पे आ जाएगा ना, मेरे को देखता हूँ कौन सा है वो।
हाँ
2013 था, 14 था, तो पुराना हो गया ना मामला, इसलिए थोड़ा भूल रहा हूँ मैं। फोर्टीन है, सॉरी 14 है वो।
अच्छा, तो चेंज कर दीजिए सर ऊपर। और
हाँ, मैं इसको थोड़ा सा बाजू में करके, मैंने अपने सारे केसेस का एक वो बना रखा ना, फोल्डर,
जी जी,
वो उसमें है ये। नाउ आई हैव टू गो बैक एंड चेंज द ईयर। ये सिविल आया, इसकी जगह करता हूँ क्रिमिनल, ये करता हूँ 14, इधर लाता हूँ SHAMLA, श्यामला
14
जाधव।
की है ना, 14 की है ना।
YH2GAT,
क्या आ गया आपका? श्यामला सिद्धार्थ यादव वर्सेस स्टेट ऑफ महाराष्ट्र एंड अदर्स। फिर हाँ हाँ हाँ, यही है, यही तो है।
एडवोकेट ना, नहीं हिरण्य को बता देते हैं। देखो ये है, केस मिल गया अब अपने को, श्यामला जाधव वाला केस। इसका रिपीटिशन नंबर क्या है? 3842। फाइलिंग डेट है 30 सितंबर।
वो
रेगुलर
सब अभी
रजिस्ट्रेशन
कुछ
नंबर आ गया
दिखाई नहीं
इसका।
दे रहा,
हाँ,
वो दिखाई नहीं दे रहा अभी, अभी दिखाई नहीं दे रहा।
अब मैं उसको शेयर करता हूँ ना, मतलब हाँ,
जी
इसको
जी
जब
जी,
यानी
वो
मैं
करो
सब देख पा रहा हूँ, कोई
हाँ,
बात नहीं।
नहीं दूसरे
ये नहीं देख
दूसरे
पा रहा।
दूसरे उसमें खुलता है ना वो जाके।
नहीं नहीं, ये बोल रहा है मैं देख पा रहा हूँ, लेकिन नहीं देख पा रहा।
दिखा?
हम्म। फाइलिंग डेट है 30th of September 2014, रजिस्ट्रेशन डेट, पिटिशनर रिस्पोंडेंट, आपका नाम है, पिटिशनर्स एडवोकेट, ये
डिस्पोजल डेट
स्टेटस डिस्पोज्ड,
30th
डिस्पोज
September
फिर
2014 it was filed, and
हाँ,
it
यस,
was
हेबियस कॉपस,
ordinance cancelled.
प्रिवेंशन ऑफ एंड डिटेंशन एंड हेबियस कॉपस,
Now it was just decided by
एएस
Justice.
ओका
Okay, now ये
एंड
सुप्रीम कोर्ट
जस्टिस
में है।
एएस गडकरी। हाँ
रूल एब्सोल्यूट।
हाँ, रूल एब्सोल्यूट। इसमें कॉफी पोसा भी था।
खपे पोसा ही है ना।
हाँ वही तो बोल रहा हूँ।
सी, ये देखो 30th September I filed, then जस्टिस ओका एंड कुलकर्णी ने इसको एडमिट किया, रूल इशू किया। इसको मैं खोलता
हाँ,
हूँ, अरे ये अलग उसमें खुलता है। इसको उसमें खोलने के लिए क्या करूं मैं? सेम
इसमें भी
उसमें
तो खुल जाता है दबाने से। ये ग्रीन ग्रीन इस पे दबाइए ना, ये खुल जाएगा। तो
ओपन
नहीं
इन
खुल
न्यू
रहा है
कर
इसमें।
रहे हैं ना ये। ओपन लिंक इन न्यू वेब बोल रहा है, ओपन लिंक इन न्यू विंडो बोल रहा है, न्यू वेब। मैं ये करता हूँ, ये न्यू विंडो में नहीं खोलना चाहिए ना, इसको यहीं पे खोलना चाहिए।
नहीं सर, ऐसे समझा दीजिए। देखिए, रूल इशू होता है, स्टेट को ये बताता है कि भाई यू गिवन आंसर, इफ नो आंसर इज गिवन देन द कोर्ट विल प्रोसीड ऑन इट्स ओन, इफ नो सैटिस्फैक्टरी आंसर इज गिवन।
अभी अभी ये दिखाई देते हैं, कोई बात नहीं, इसको भी दिखा देते हैं। क्या क्या करता है, बिकॉज हम लोग तो समझते हैं, लेकिन हिरन में जैसे बाहर वालों पब्लिक जो देख रही है, उनको बोलेंगे ये लोग शॉर्टकट मार रहे हैं।
ये फर्स्ट डे ऑफ हियरिंग था, उस दिन रूल इशू किया गया।
देखा?
जी जी,
वीपी सिंह पर पटिशनर
लर्नड, हाँ, लर्नड असिस्टेंट पब्लिक प्रोसिक्यूटर वेव सर्विस फॉर रिस्पोंडेंट्स नंबर 1, 2 and 4 and 5. Rule is made returnable on 11th of November 2014. Petition to be listed on Delhi Port at 3 p.m.
हो गया। Now let us come back to the 11th को. अब इसके बाद में क्या हुआ फिर? ये आया है 1 दिसंबर को आया है, क्योंकि पहले बीच में शायद आया था, उसको सुना नहीं था, कुछ ऐसा कुछ था गड़बड़ मेरे ख्याल में. Anyway,
हो सकता है, कभी कभी छुट्टी रहता है, कुछ रहता है, या कोई दूसरा मैटर रहता है.
नहीं, उस दिन
ठीक है, हो
किसी और को लेके बैठ गया था वो. बोला ठीक है
हाँ,
हम
वही बोल रहा हूँ मैं कि कुछ ना कुछ रहता है, कभी कभी होता है ऐसा.
बट इनका ये था कि ही यूज्ड टू कीप द हियरिंग एट 3 o'clock ओनली. मॉर्निंग में इधर उधर नहीं
अच्छा,
करते थे.
लिखा हुआ है 3 PM. हाँ, 3 PM लिखा हुआ है. 1st December 2014. For the reasons separately recorded, we pass the following order. The rule is made absolute in terms of prayer clauses A and B, which read as the issue of writ of habeas corpus or any other appropriate writ order of direction, washing and setting aside the impugned detention order bearing number so and so. Direct the detainee be released from the detention forthwith and set at liberty. All concerned to act upon an authenticated copy of this operative part of the judgment and order.
ना बॉम्बे हाई कोर्ट क्या करता है, डिटेल ऑर्डर बाद में देगा. डिटेल ऑर्डर पढ़ाता हूँ अभी.
हाँ, ये आपका जो प्रेयर है वो दे दिया.
हाँ, अभी
प्रेयर सेट आउट कर दिया.
हाँ,
नहीं, ये दिखा रहे हैं, अच्छा कर रहे हैं. ये सबके लिए मतलब ठीक रहेगा, और लोगों के लिए भी जो दूसरे हाई कोर्ट्स में उनका सिस्टम कुछ और अलग है थोड़ा सा. इसमें पूरा दिया हुआ है, एड्रेस वगैरह, नाम, मदर ऑफ डेटिन्यू, द डिटेन्ड पर्सन, स्टेट ऑफ महाराष्ट्र, प्रिंसिपल सेक्रेटरी, अपील्स एंड सिक्योरिटी, गवर्नमेंट ऑफ महाराष्ट्र. State of Maharashtra represented through Secretary, Home Department, Special.
सेकंड इज राजीव, प्रिंसिपल सेक्रेटरी,
हाँ,
जिसने पास किया
प्रिंसिपल
था.
सेक्रेटरी, अपील एंड सिक्योरिटी, होम डिपार्टमेंट स्पेशल, डिटेनिंग अथॉरिटी. अच्छा, यही था, एंड डिटेनिंग अथॉरिटी. फिर मिनिस्ट्री ऑफ फाइनेंस, कमीशन ऑफ कस्टम्स प्रिवेंटिव, सुपरिटेंडेंट ऑफ प्रिजन्स, नासिक सेंट्रल प्रिजन. फिर आपका नाम कौन कौन अपीयर किया है, फिर रेस्पोंडेंट के तरफ से
शिंदे
कौन
साहब जज
कौन
बन गए,
अपीयर.
हाई कोर्ट के जज हैं अभी. हाँ, ये शिंदे जो है ना जज
अच्छा
है.
अच्छा, एसके शिंदे.
गडकरी भी पहले हमारे साथ में एडवोकेट था. गडकरी इसमें बैठा है ना बेंच में.
हाँ हाँ हाँ,
गडकरी
you have
साहब
the
का
name,
आगे गए.
A.S. Gadkari. The petitioner, the mother of the detainee, Harish Siddharth Yadav, has preferred this writ petition under Article 226 of the Constitution of India for a writ of habeas corpus. Habeas corpus means produce the person, and for setting aside the impugned detention order bearing number so and so, dated so and so, issued by the respondent number 2. 2 means that gentleman जो अभी आप पढ़ाए थे. By the said order dated 16th of September, the petitioner was ordered to be preventively detained by the respondent number 2 in exercise of powers under section 3(1) of the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974. For brevity, the Coffee Posa Act. Heard the learned counsel appearing for the petitioner and the learned APP appearing for the respondents. We have also perused the record produced by the learned APP minutely. The learned counsel appearing for the petitioner submitted that the representation preferred by him in support of the challenge to the said preventive detention order has been decided by the detaining authority, state government, with inexplicable delay, and hence the said order stands vitiated in view of the constitutional mandate embodied under Article 22(5) of the Constitution of India.
हम लोग
Vitiated,
करते रहे ना यहाँ पे, इसीलिए.
inexplicable delay, detention order. The learned counsel appearing for the petitioner submitted he has taken a specific ground in paragraph number 7R of the petition to the effect and has invited our attention to the same. He submitted that the petitioner made a composite representation on 29th of September through the superintendent Nashik Road Central Prison to the detaining authority and others, and the same came to be decided and communicated to the detainee at Nashik Road Central Prison on 31st of October 2014, years before us, that the detaining authority as well as the sponsoring authority had utterly failed to explain the delay in deciding his representation expeditiously, which has caused the continuation of the order of preventive detention to vitiate. In support of his contention, the learned counsel appearing for the petitioner has relied upon a judgment of the division bench of this court, to which one of us, Shri A.S. Okha Justice, is a member, dated 2nd of May 2014, passed in criminal writ petition number so and so, in the case of Riaz Ahmed Batatawala versus the state of Maharashtra and others. Per contra, the learned APP supported the order of detention passed by the respondent number 2 and submitted before us that the sponsoring authority as well as the detaining authority have properly explained the alleged delay by way of filing their respective affidavits. The learned APP, relying upon the statements made in the reply submitted, there was no inordinate delay in disposing of the representation, and assuming that there was a delay, if any, caused in deciding the representation, that has been properly explained in the reply. Matlab affidavit mein. It is to be noted that that in response to the petition, Sri Shivaji S. Patankar, Deputy Secretary, Home Department, Government of Maharashtra Mantralaya, Mumbai, has filed an affidavit in reply dated 21st November 2011 for on behalf of the respondent numbers 1 and 2, that is the state of Maharashtra and the detaining authority, and has also filed an additional affidavit dated 20th of November 2014, thereby explaining the movement of the representation and the steps taken by the respondents number 1 and 2 in deciding the representation of the petitioner with utmost diligence. Sri Prabhakar Kumar, Deputy Commissioner of Customs Preventive MNP Wing, MIU, MPIU 2, Mumbai, has filed an affidavit dated 21st November on behalf of the sponsoring authority. This is respondent number 4 in response to the petition. At the time of hearing of the present petition, the respondent number 4, that is the sponsoring authority, through the additional public prosecutor, tendered in this court a detailed chronology explaining the time taken in disposing of the representation of the detainee, Harish S. Yadav. Before we proceed to deal with the present petition on its own merits, before we proceed to deal with the present petition on its own merits, it is necessary to place a useful reliance on the three decisions of the Honorable Supreme Court, wherein the Supreme Court has laid down the law with respect to the decision of the representation of a detainee as contemplated under Article 22(5) of the Constitution of India. The first decision is in the case of Harish Pawar versus the state of UP, wherein the apex court has held thus, in our opinion, the manner in which the representation made by the appellant has been dealt with reveals a sorry state of affairs in the matter of consideration of representation made by the persons detained without trial. There is no explanation at all as to why no action was taken in reference to the representation on 4th, 5th, and 25th of June 1980. It is also not clear what consideration was given by the government to the representation from 13th of June 1980 to 16th of June 1980, when we find that it culminated only in a reference to the Law Department. Nor it is apparent why the Law Department had to be consulted at all. Again, we fail to understand why the representation had to travel from table to table for 6 days 6 days before reaching the chief minister, who was the only authority to decide the representation. We may make it clear, as we have done on numerous earlier occasions, that this court does not look with equanimity upon such delays when the liberty of a person is concerned. Calling comments from other departments, seeking the opinion of secretary after secretary, and allowing the representation to lie without being attended to is not the type of action which the state is expected to take in a matter of detention.
ये पावा का जो साइटेशन है AIR
जी
1981 SC
हाँ
1126
दिया हुआ such vital import. We should emphasize that it is the duty of the state to proceed to determine representations of the character mentioned above with utmost expedition, which means that the matter must be taken up for consideration as soon as such a representation is received and dealt with continuously until it is absolutely necessary to wait for some assistance in connection with it, until a final decision is taken and communicated to the detainee. This not having been done in the present case, we have no option but to declare the detention unconstitutional. We order accordingly allow the appeal and direct the appellant to be set at liberty forthwith. Appeal allowed. The second judgment is in the case of Rajamal versus State of Tamil Nadu and another, wherein the Supreme Court has held that a duration or range of delay in disposal of the representation is not material. The Supreme Court in paragraph 9 of the said decision has held thus. The position, therefore, now is that if the delay was caused on account of any indifference or lapse in considering the representation, such delay will adversely affect further detention of the prisoner. In other words, it is for the authority concerned to explain the delay, if any, in disposing the representation. It is not enough to say that the delay was very short. Even longer delay can well be explained. So the test is not the duration or range of delay, but how it is explained by the authority concerned. The third decision of the Supreme Court is in the case of Rama Dhondu Borade versus V.K. Saraf, Commissioner of Police and others, wherein the Supreme Court has held in paragraph numbers 19 and 20 as under. The propositions deducible from the various reported decisions of this court can be stated thus. The detainee has an independent constitutional right to make his representation under Article 22(5) of the Constitution of India. Correspondingly, there is a constitutional mandate commanding the concerned authority to whom the detainee forwards his representation, questioning the correctness of the detention order clamped upon him and requesting for his release, to consider the said representation within reasonable dispatch and to dispose the same as expeditiously as possible. This constitutional requirement must be satisfied with respect, but if this constitutional imperative is observed in breach, it would amount to negation of the constitutional obligation, rendering the continued detention constitutionally impermissible and illegal, since such a breach would defeat the very concept of liberty, the highly cherished right which is enshrined in Article 21 of the Constitution. True, there is no prescribed period, either under the provision of the Constitution or under the concerned detention law, within which the representation should be dealt with. The use of the word "as soon as may be" occurring in Article 22(5) of the Constitution reflects that the representation should be expeditiously considered and disposed of with due promptitude and diligence, and with a sense of urgency and without avoidable delay. What is reasonable dispatch depends on the facts and circumstances of each case, and no hard and fast rule can be laid down in that regard. However, in the case, the gap between the receipt of the representation and its consideration by the authority is so unreasonably long, and the explanation offered by the authority is so unsatisfactory, such delay would vitiate the order of detention. So this is the yardstick. Thus, after taking into consideration the ratio laid down by the Honorable Supreme Court, we proceed to deal with the contentions raised by the petitioner about the delay caused by the detaining authority state in deciding his representation. In the affidavit dated 21st of November 2014, filed on behalf of the respondents number 1 and 2, as stated herein above, in paragraph 17, the respondents have responded to the contentions the petitioner raised in paragraph 7R about the delay in deciding his representation. The said paragraph 17 reads as under. With reference to paragraph 7R of the petition, I say that the detainee submitted composite representation dated 29/9/2014 through Superintendent Nashik Road, Central Prison, Nashik, which was received in the office of the detaining authority on 8/10/2014. There were holidays on 2/10/2014, 3/10/2014, 5/10/2014, and 6/10/2014 on account of such and such occasions. The concerned assistant submitted for calling parawise on 9/10/2014. The section officer and the deputy superintendent both endorsed it on 10/10/2014. There were holidays on 11th and 12th on account of second Saturday and Sunday. The detaining authority approved the note and the draft letter on 13th. The section officer was on election duty from 13th to 16th. Hence, the letter was sent on 14/10/2014. The sponsoring authority forwarded Paraguay's comments by letter dated
1 मिनट
28/10/2014.
देखो यहाँ क्या बोल रहा है 14/10
14/10 बोल रहा है और
तो
यहाँ
यहाँ
बोल रहा है
पे
28/10.
14 दिन का डिले हो गया ना यहाँ पे
हाँ हाँ हाँ. The
जबकि मम्मी में
concerned
ये
assistant was
ठंडी
on,
बैठी हुई है
the concerned assistant was on leave from 28/10/2014 to 1/11/2014. The Paraguay's comments were submitted by the concerned section officer 28/10/2014. After considering the representation of the detainee and the Paraguay's comments of the sponsoring authority, the detaining authority rejected the representation on 30/10/2014. The approved intimation letter was forwarded to the detainee through Superintendent Nasik Road, Central Prison Nasik on 31/10/2014. Further, I crave leave to reply upon the affidavit of the sponsoring authority as and when required. In the additional affidavit dated 20th of November 2014, filed on behalf of the respondent numbers 1 and 2, the delay which was caused at the instance of the detaining authority in deciding the representation of the petitioner has further been tried to be explained by the said authority in paragraph number 2. With reference to paragraph 7R of the petition, I say that the detainee submitted composite representation dated 29/9/2014 through superintendent of the prison, which was received on 4/10/2014. There were holidays on ये लिखने का कोई जरूरत नहीं था. 5/10 6/10 ये सब. The section
तो
officer
कॉपी
and the
पेस्ट करते
deputy
हैं ना
secretary
फटाफट पे
both endorsed it on 10/10/2014. The additional chief secretary home approved the note and the draft letter on 10/10/2014. The letter was sent to the sponsoring authority on 10/10/2014. There were holidays on 11th and 12th. On account of second Saturday and Sunday, the section officer was on election duty from 13th to 16th. The sponsoring authority forwarded Paraguay's comments by letter dated 28/10/2014. अच्छा, यदि ये असिस्टेंट ये सेक्शन ऑफिसर 16 तक भी मतलब छुट्टी मतलब ये इलेक्शन ड्यूटी में है तो फिर ये क्या लिख रहा है? स्पॉन्सरिंग अथॉरिटी फॉरवर्डेड द पैरावाइज कमेंट्स बाय लेटर ऑन 28
ये है ना
16
इधर
टू.
ये इसकी बात कर रहा है वो
अच्छा. हाँ
10th को भेजा तो
हाँ तो
स्पॉन्सर पार्टी ने 28/10 को उसका जवाब भेजा ये बोल रहे हो
हाँ तो 2 दिन ठीक है ये था तो फिर भी डिले तो है ही. द कंसर्न असिस्टेंट वाज ऑन लीव ऑन 28/10 to 1/11. फिर the Paraguay's comments were submitted by the concerned section, which was kept for perusal of the additional Home Secretary on 29th. From 30th to 1/11, the additional Chief Secretary was busy in preparing the list and details which were called by the new government. There were holidays on 2/11, 4/11, 6/11, 8/11, 9 on account of such and such due to formation of new government. The additional chief secretary home was busy in other official work and administrative work on 7/11. After considering the representation of the detainee in detail and the Paraguay's comments from the sponsoring authority in detail, finally the additional chief secretary home rejected the representation on 10/4/2014. The draft rejection intimation letter was submitted by the concerned section officer on 10/11/2014, which was approved by the deputy secretary on the same day. The approved rejection intimation letter was forwarded to the detainee through superintendent of the prison on 11/11/2014. फिर बोला rely upon record of the sponsoring authority. Affidavit in reply of the sponsoring authority filed by Prabhakar Kumar in paragraph 2012 has simply stated that with reference to paragraph 7R of the petition, no comments are offered as the said paragraph pertains to the action taken by the detaining authority. As stated herein above, during the course of hearing the petition, the respondent number 4, that is the sponsoring authority, through the learned APP, has tendered in this court a chronology details of time taken in disposing of the representation of the detainee. The said chronology reproduced below for the sake of convenience. फिर वही चीज लिख रहा है कब मिला उसके बाद 5 आदमी को और पकड़ा क्या किया नहीं किया. Analyze the writ petition, bail application, lookout. अच्छा After taking into consideration the affidavit and replies filed by a detaining authority and the chronology of events, it is an admitted position that the detainee submitted a composite representation, which was received in the office of the detaining authority on 8th of October 2014, and the same came to be decided on 30th of October 2014. The said decision was informed to the detainee on 31st of October. It is pertinent to note that the detaining authority has not explained as to what was the necessity for seeking the parawise remarks from the sponsoring authority for deciding the representation of the petition as per the said affidavit. The delay of 14 days from 14th of October to 20th of October.
This was my argument. Huh? The
What was the
detention
need
order has
for
been prepared
seeking
by you.
parawise?
Why are you asking sponsoring authority to give comment on the
From
detention
someone
order
else,
that is prepared by
from
you?
someone else.
Huh?
From someone else. Why do you ask for parawise comments?
Yes.
As if you are not competent enough.
हाँ, तो यही भी
Correct.
गड़बड़ कर रहा है ना वो देखो.
Delay of 14 days.
It is pertinent to note here that the detention authority has not explained as to what was the necessity for taking
What was the
parawise
necessity for seeking the parawise remarks
and for
from the
deciding
sponsoring
this.
authority?
So there is delay of 14 days, no, straight.
It has
Has
not
not
at
at
all
all
been
been
explained by the detaining authority. The said non-explanation of delay and the overall delay caused in deciding the representation of the petitioner, in our opinion, is fatal, and the same vitiates the continuation of the order of preventive detention. It is further pertinent to note here that in the additional affidavit dated 20th of November 2014, in paragraph 2, the detaining authority has stated that the composite representation submitted by the detainee dated 29th of September 2014 was received by the detaining authority on the 4th of October 2014. If the statement made in paragraph number 2 of the affidavit dated 20th November 2014 is accepted to be true, then it adds 4 days in deciding the representation of the detainee by the detaining authority, which comes to 18 days of inexplicable delay. It is further surprising to note that the detaining authority has taken a bold stand. Apart from there were a substantial number of public holidays due to the formation of the boldly बोल रहा है, नया government हुआ, additional chief secretary home was busy in other official work. All this is nonsense. Court is not interested in all this. No? The said explanation given by the detaining authority is unreasonable and cannot withstand a law laid down in the case of Rama Dhondo Godare Supra. That after considering the representation of detainee in the parawise comment from the sponsoring authority in detail, finally, the additional chief secretary home rejected the representation on 10th of November. In this affidavit, it has been stated that the rejection intimation letter was forwarded to the detainee through the superintendent of the prison, and the said affidavit dated 24 November 2014, the same authority has on oath stated that the rejection intimation of the detainee's representation was communicated to him in prison on 31st of October.
See
If the
here.
statement made in paragraph 2 of the additional affidavit is accepted to be true, then the detainee received the intimation about the rejection of his representation in prison 11th of November, thereby adding 11 more days of delay. ये बढ़ते ही जा रहा है time. Deciding the representation of the petitioner. तो ये आप खोज कर दिखाए होंगे ना, ये ऐड करके. This
हाँ,
takes us to the chronology
वीडियो
of
पढ़ने के
events.
बाद मैं और बताया ना, मैंने कहा था 31st
नहीं,
से
गलत
बात
chronology
छोड़ दिया था मैंने.
takes us to the chronology of events submitted by the sponsoring authority and submitted the parawise comments to the detaining authority. In the chronology submitted by the sponsoring authority is stated that on 13th October 2014, they received the representation from the Home Department at 1750 hours, that is 5:50 p.m. and they forwarded the parawise comments to the Kofeposa Cell Mantrala on 20th of October 2014. It is to be noted here that there is no explanation at all which has been offered by the sponsoring authority about the period of 15 days which they consumed for submitting the parawise comments to the detaining authority. And the said chronology gives irrelevant and redundant events. जो मैं बोल रहा था बेकार सब छुट्टी का कहानी है और ये सब मैं ही बोल रहा था
ये जा रहा
irrelevant
था,
and
मैं यहाँ जा
redundant.
रहा था, मैं वहाँ जा रहा था. प्रोफेसर साहब
बेकार,
छुट्टी पे थे,
court is
प्रोफेसर
not
साहब मीटिंग में
interested
थे.
in all this, na? In
हाँ.
the interim regnum period, The delay caused at the instance of the sponsoring authority in submitting the Parawise comments to the detaining authority is undoubtedly inexplicable and also adds to the vitiation of the impugned detention order. Thus, there is no satisfactory explanation at all as to why the sponsoring authority did not submit Parawise comments to the detaining authority. The said delay in submitting the Parawise comments is not at all explained in the affidavit of the sponsoring authority. Further, the detaining authority has also utterly failed to explain the delay caused at their end in deciding the representation of the detainee expeditiously, and the reasons given by the detaining authority cannot be accepted. This unexplained delay certainly vitiates the constitutional mandate as embodied in Article 25(2) of the Constitution of India, and therefore, in our considered opinion, the continuation of the order of preventive detention dated 16 September 2014 stands vitiated. We further hold that there is complete absence of explanation for delay insofar as rejection of the representation made by the petitioner to the state government is concerned. Thus, after taking into consideration the aforesaid facts, the petitioner deserves to succeed as the constitutional safeguard contemplated under Clause 5 of Article 22 has been violated. Hence, we pass the following order. The rule is made
Proceed,
absolute in terms of prayer clauses A and B, जो आप दिए थे prayer में. Issue writ of habeas corpus, the quashing, setting aside the impugned detention order. Direct the detainee be released. ये आपका जो है वही set out किया prayer. मतलब वो allow कर दिया.
ये पीछे बैठा हुआ क्या? ये पार्क में चलते जाता है? अच्छा,
पता नहीं क्या पीछे था क्या?
हाँ, ये बैक में
पीछे
था, बैक स्टेज में था।
क्यों
हाँ,
आपने
पीछे थे
केस स्टडी बंद कर दिया अचानक?
अब हो गया ना
मतलब केस स्टडी बंद कर दिया प्रेजेंटेशन?
हाँ
केस स्टडी का
ऑलमोस्ट हो गया
प्रेजेंटेशन
ना.
हो गया?
और देखना है?
हाँ हाँ
और देखना है? दूसरा देखना है?
नहीं और देखना नहीं है, परंतु ये जो आर्टिकल है आर्टिकल 22, इसका मतलब बेसिकली तो यही है कि एक ही सजा मतलब अपराध के लिए 2 बार सजा नहीं होगी.
नहीं, ये दूसरा चीज है.
तो आर्टिकल 22 क्या कहता है?
States that
मैंने
when any person is detained in pursuance of any order made under any law providing for preventive detention, the authority making the order shall, as soon as it may be, communicate to such person the ground on which the order has been made and shall afford him the earliest opportunity of making representation against the order. Parliament may by law prescribe the circumstances under the a person may be detained for a period longer than 3 months under any law providing for preventive detention without obtaining the opinion of advisory board. इसका प्रिंसिपल क्या है कि आपने मुझे जमा कर दिया, डिटेन कर दिया. नाउ अगर मैंने वो ऑर्डर पढ़ा जिसके बेसिस पर आपने मुझे अंदर डाला है, जो ग्राउंड है उसको मैंने पढ़ा और मैंने रिप्रेजेंट किया. नाउ आई एम इन जेल, so I will represent through सुप्रीम ऑफ पुलिस जेल, वहीं से वो करूंगा. एंड जिसने ऑर्डर पास किया है वो उसके पास रिप्रेजेंटेशन भेजेगा सुप्रीम ऑफ पुलिस. नाउ
इनको समझा दीजिए सर रिप्रेजेंटेशन क्यों देते हैं. Because I'm dissatisfied with the detention order, the grounds of detention, I'm dissatisfied with that. So I'm making a representation through the superintendent of that jail to the authority who has passed the detention order.
Now here detaining authority who is passing the order is different and the person who is sponsored detention is different. हाँ, ये ध्यान रखना.
जी.
मंत्रालय passes the order in the sense that additional secretary prevents, जो होता है ना होम सिक्योरिटी वाला या होम डिपार्टमेंट वाला होता है, वो डिटेनिंग अथॉरिटी होता है, वो पास करता है. चाहे एनएसए का हो, चाहे वो काफे पोसा का हो, कोई भी प्रिवेंटिव डिटेंशन जो होगा वो पास करेगा. ये जैसे अभी ये यूएपीए आया है, अनलॉफुल एक्टिविटीज वाला जो आया है, उसके में ये सही होता है. तो स्टेट गवर्नमेंट में ये पास करेंगे और सेंटर में जैसे कापूपोसा के लिए है तो रेवेन्यू सेक्रेटरीट के अंडर में एक अलग से डिपार्टमेंट बना हुआ है, उसको बोलते हैं CEIB. ठीक है, तो वो उसको वहां पर क्या है वो अरे
सर इसका फुल फॉर्म बताइएगा जो भी आपने बोला.
सेंटर ब्यूरो ऑफ इंटेलिजेंस यूनिट करके है, वो कुछ ऐसा करके है. ठीक है, तो वो लोग वहां से पास करते हैं दिल्ली में, उसका ज्वाइंट सेक्रेटरी लेवल पे होता है। तो पुलिस कमिश्नर को अगर कोई डिटेंशन इश्यू करना है एनएसए का, तो पुलिस कमिश्नर अपना पूरा प्रपोजल जो है वो होम मिनिस्ट्री को भेज देगा। अब होम मिनिस्ट्री में जो एडिशनल सेक्रेटरी है वो उसको पास करेगा ऑर्डर। तो जब सुप्रीडेंट ऑफ जेल अपने रिप्रेजेंटेशन को, जो डिटेन्यू है उसके रिप्रेजेंटेशन को जब भेजता है, तो वो भेजता किसको है, जिसको जिसको वो एड्रेस होता है। अभी मैंने क्या किया था, कंपोजिट रिप्रेजेंटेशन है, मतलब एक ही रिप्रेजेंटेशन में मैंने एडिशनल सेक्रेटरी को भी लिखा हुआ था,
जी,
उसी
जी।
रिप्रेजेंटेशन में मैंने इसको एमएनपी को भी लिखा हुआ था, कमिश्नर ऑफ कस्टम्स एमएनपी जो स्पॉन्सरिंग अथॉरिटी था उसको लिखा हुआ था, और उसी रिप्रेजेंटेशन में मैंने दिल्ली के जेएस को भी लिखा था। दिल्ली के जेएस को क्यों लिखना होता है, क्योंकि जब आप कोई डिटेंशन ऑर्डर स्टेट गवर्नमेंट पास करती है तो उनको वो पूरे डिटेंशन ऑर्डर का ग्राउंड और पूरा मटेरियल जो है दिल्ली भेजना पड़ता है। जो दिल्ली की जो ट्रेनिंग अथॉरिटी होती है वो भी उसको देखती है कि हाँ डिटेंशन ऑर्डर बराबर है कि नहीं है। अगर उसको भेजने में आपने गड़बड़ कर दिया, डिले कर दिया, देन ऑल्सो माई फंडामेंटल राइट इज विसिएटेड। तो यहाँ यह हो रहा है कि जब जेल से आपके पास जब पहुंच गया तो आप उसको विदाउट अनड्यू डिले आप उसको कंसीडर करो, क्योंकि अगर मान लो मेरे ग्राउंड सस्टेनेबल हैं और उन ग्राउंड में मैं छूट
जी,
सकता
जी।
हूं, तो जितने दिन तक आपने मुझे इलीगली जमा करके रखा है वो तो गया ना, फिर मेरा फंडामेंटल राइट तो विसिएट हो गया ना। अब यहाँ पर ये क्या कर रहे हैं, आराम से 14 दिन तक सो रहे हैं। कभी बोलता है कि सेक्शन ऑफिसर छुट्टी पे, कभी बोलता है एडिशनल चीफ सेक्रेटरी नई गवर्नमेंट बनी है उसको बनाने में बिजी है, और वो जो स्पॉन्सरिंग अथॉरिटी बोलती है कि हमारे को 14 तारीख को मिला और हमने 28 तारीख को जवाब दिया, तो तुम 14 दिन क्या कर रहे थे बैठे हुए। तो ये सारा होता है, इसमें होता है कि आप मेरे फंडामेंटल राइट को विदाउट रीजन, विदाउट एनी एक्सप्लेनेबल रीजन आप मेरे फंडामेंटल राइट को हैम्पर नहीं कर सकते, जेपरडाइज नहीं कर सकते। ये
सर और एक चीज मैं बताऊं सर,
हाँ।
आप एक बढ़िया काम किए थे उस रिप्रेजेंटेशन में, 1 2 3 ऊपर सबको दे दिए थे। अब ये कोई बोल नहीं सकेगा कि मेरे को अलग मिला था, इसको अलग मिला था। सबको पता था, एक ही बारी में सबको पता था।
हाँ,
मतलब एक के पास पहुंचा तो बाकी लोगों के पास जो गया वहां भी वो भी पता था, तो दे शुड हैव कोऑर्डिनेटेड ना। ये भी एक बड़ा मतलब अच्छा चीज किया आप। एक ही रिप्रेजेंटेशन में आप तीनों को दे दिए ना, इसमें फंस गया और ज्यादा, क्योंकि इनका जो रिप्लाई पूरा अनसेटिस्फैक्ट्री है, इनएक्सप्लिकेबल डिले और विथ इम्प्रॉपर रीजंस, वहीं तो फंस गया ना।
हाँ। एक और पढ़ाता हूँ, इसमें भी ज्यादा नहीं पढ़ना, सिर्फ जो उसका ऑपरेटिव पार्ट है वो पढ़ना। ये भी
जी,
सेम
जी।
चीज पे है, 2014 का ही है वो भी।
अच्छा, हिरण्मय को वो भी बता दीजिए, नॉर्मल आईपीसी में 24 घंटे के अंदर जो है आपको नियरेस्ट मैजिस्ट्रेट के पास प्रोड्यूस करना पड़ता है। और कोर्ट में इफ यू डू नॉट हैव एनी लॉयर, यू हैव टू tell the court that I do not have a lawyer. If you are a poor person, then you have the right to be represented by a lawyer from the court. Court will arrange for that.
वो पब्लिक
That is in other
पीपी को
cases.
अरेंज करेंगे, मतलब पब्लिक प्रोसिक्यूटर।
नहीं, कोर्ट को बोलना पड़ेगा, आपको कोर्ट को बोलना पड़ेगा,
नहीं,
मैजिस्ट्रेट।
मतलब कोर्ट को बोलना पड़ेगा, फिर कोर्ट एक पब्लिक प्रोसिक्यूटर अरेंज करेंगे।
पब्लिक प्रोसिक्यूटर नहीं, मतलब किसी को भी करेगा, कोर्ट जिसको अच्छा समझेगा करेगा।
अच्छा, ठीक है। नहीं, ऐसा हो सकता है ना कि मतलब जो विक्टिम है वो थोड़ा क्या कहते हैं, गरीब आदमी है, पैसा।
तो स्टेट पब्लिक प्रोसिक्यूटर तो प्रोसिक्यूशन करता है ना, वो क्यों आपका केस लेगा? कोर्ट कोई भी लॉयर को देगा, दूसरा लॉयर को, डिफेंस लॉयर देगा आपको।
ये भी सिंह कुछ ढूंढ रहे शायद।
मैं एक दूसरा उसी ईयर ओक साहब के जजमेंट है, दूसरा एक और भी है, एक गडकरी साहब ने लिखा था, मैं ओक साहब का थोड़ा सा जजमेंट दिखाना चाह रहा था। Now I'll not go into that कि कैसे कैसे देखते हैं, वो सबको दिखा दिया मैंने कैसे होता है। Now स्टेट में जजमेंट में जाते हैं,
ऑपरेटिव पार्ट में चले जाएंगे।
आ गया?
जी आ गया सर। सर एक सेकंड जरा सा मैं वो
इसमें जो पटिशनर
जी
है वो
जी
वाइफ है डिटेन्यू की।
जी जी जी
इसमें
दीपक जोशी।
हाँ, इसमें फिर ये है स्टेट ऑफ महाराष्ट्र सेम थी, राजीव सेम सेक्रेटरी।
ये भी समझा दीजिए सर, क्योंकि दैट पर्सन इज ऑलरेडी इन प्रिजन,
हाँ।
दैट पर्सन हैज टू बी रिप्रेजेंटेड बाय अ फैमिली मेंबर।
इसके पहले
या
इसमें
तो
लिखा
वो
हुआ है
पिट
ना,
हाँ वो तो पिटिशनर नहीं बन सकता ना।
यहाँ पे है ना,
हाँ जी।
ये क्या लिखा है?
जब
The order of
चैलेंजेस
detention was passed against
हाँ
Deepak Joshi. The present petition is by the wife of detainee.
हम्म,
ऐसा है। ये ओक साहब ने पास किया है ऑर्डर 12
जी
जनवरी 2015 को।
हम्म।
अब इसमें क्या है, सीधा ओक साहब
वेरियस
बोलते
ग्राउंड्स ऑफ चैलेंज।
व्हाट इज योर बेस्ट ग्राउंड, तो उनको बोलना पड़ता था। अगर वो ग्राउंड नहीं चला तो फिर बोलते दूसरे ग्राउंड पे जाओ, डोंट वेस्ट टाइम ऑफ द
जी
कोर्ट,
जी
ऐसा बोलते थे वो।
जी जी जी।
यहाँ पे क्या बोल रहे हैं, among various ground of challenge as in this petition the learned council appearing on
ग्राउंड
behalf।
1 आई
हाँ, अब इसमें कौन कौन है देखो,
रोमन।
मेरे साथ में संतोष शेट्टी करके था,
संतोष शेट्टी।
और ये जेपी याग्निक फॉर 1 and 2 and 5।
हाँ वो तो उनका हाँ
हाँ, और ये अरुणा पई,
मतलब
अरुणा पई को जज बना रहे थे, लेकिन बाद में वो कर दिया क्योंकि उसकी उम्र ज्यादा हो गई है। बहुत डरती है मेरे से ये, बाप रे।
क्यों सर?
तो बोलती है कि कोई भी केस को मेरा तो रिकॉर्ड है ना, मैंने बॉम्बे हाई कोर्ट में जितने भी डिटेंशन मैटर डाले किसी पे मैं हारा ही नहीं ना। और ये सारे के सारे
अच्छा अच्छा
मतलब इनका ये रहता है कि ये तो यहाँ तक बोलते हैं ना कि क्लाइंट को बोलते हैं वहां पे नासिक में कि बीबीसी को मत करना,
अच्छा
हम तुमको पैसा देते हैं, दूसरा वकील तुम ले लो, हम वकील को पैसा हम दे देंगे, ऐसा बोलते हैं।
ताकि वो हार जाए।
इनका रिकॉर्ड खराब होता है ना फिर पीपी का। 78 से प्रैक्टिस कर रही है, फर्स्ट टाइम उसको मैंने 2012 में नचाया था अच्छी तरीके से, रोती भागी थी वो कोर्ट के बाहर।
नहीं नहीं, एक बात मैं बोलूं, जहाँ प्रॉपर ग्राउंड है तो इसमें रिकॉर्ड खराब हो तो कोई उपाय तो है नहीं ना। जहाँ ग्राउंड ही नहीं है तो नया ग्राउंड थोड़ी ना मैन्युफैक्चर करेगी।
इनके दिमाग में क्या है कि देखो, इनके दिमाग में यह है कि इनके जो कोटरी है ना, इनके जो जान पहचान वाला एडवोकेट है जो हाईकोर्ट में बैठता है, जो इनके सामने, और मैडम क्या हाल है, कैसे हो, आ जाओ चाय पी लो, आप कॉफी पी लो,
हाँ
वो
हाँ
वाला तो
हाँ
मैं काम करता नहीं हूँ। मेरा तो अपना डिफरेंट ऑफिस है और मैं डिपार्टमेंट में था,
बिल्कुल
तो मुझे तो इनसे कोई
बिल्कुल
मतलब नहीं है। इनके साथ में दोस्ती करने की जरूरत थोड़ी ना कि हाँ ठीक है
कोई
मैं
जरूरत नहीं
आपको
है।
आज चाय पिला देता हूँ, थोड़ा सा मेरे फेवर में रहना, ज्यादा बोलना मत। मैं तो इनको बोलता हूँ कि तुमको जितना बोलना है उतना बोलो।
जितना बोलना है बोलो। हाँ हाँ,
हाँ, तो इनको
क्योंकि
डर इस
आपको
बात
तो
का
पता है
लगता है
कि कहाँ फंस जाएगा ये।
कि कहाँ पर, मतलब समस्या ये है कि जब ये एफिडेविट फाइल कर देते हैं उसके बाद में जब कोर्ट के सामने प्रेजेंट करता है तो इनको नहीं मालूम पड़ता कहाँ हमारी मारेगा ये। दूसरे एडवोकेट क्या होते हैं जो हाईकोर्ट में नॉर्मल प्रैक्टिस कर रहे हो तो बोलता है ठीक है मैडम मैं इस बात को लेके आने वाला हूँ, आप इसमें तैयारी कर लो।
वो तो ठीक नहीं है, ये मतलब तरीका एकदम ठीक नहीं है।
ये वाला जजमेंट थोड़ा
उसमें
पढ़
तो,
के देखो क्या बोल रहे हैं।
जी सर।
अरुणा पई को किस तरीके से
Amongst various grounds of challenge urged in this petition, वो ground I, the memorandum of petition regarding the delay in disposal of the representations made by the detainee to the detaining authority, the state government, the central government, the state advisory board, where there is an affidavit filed by Sri Suvanso, Assistant Director DRI Mumbai, on behalf of the sponsoring authority. There is also an affidavit in reply filed by VM Patil, Deputy Secretary, Home Department, on behalf of the detaining authority. In the affidavit stated that the same was filed on behalf of the state of Maharashtra as well. The submission of the learned counsel appearing for the petitioner is that the affidavit of Sri VM Patil itself discloses that there is gross and unexplained delay in disposing of the representation made both to the detaining authority and the state government. The submission is thus there was no reason to call for the remarks of the sponsoring authority, and there was a gross delay by the sponsoring authority in submitting its remarks, parawise comments, which is not explained. He relied upon various decisions. बार बार यही गलती लोग करते हैं क्या? हाँ सर, बार बार यही गलती करते हैं क्या? learned APP representing the state and the detaining authority relied upon the decision of the apex court in the case of. He urged that this is not a case where there is an indifference on the part of the concerned authorities, but this is not a case of an avoidable delay. He urged that in any case there was a satisfactory explanation for the delay. The council representing this content the delay is very short. She submitted ये तो बोले there is an unexplained delay. The order of detention would not be vitiated. We have given careful यहाँ से पढ़ना होगा. We have given careful considerations to the submissions. As far as the issue of delay is concerned, if the time taken in deciding the representation is unreasonable and the explanation furnished for the said delay is unsatisfactory, the same has the effect of vitiating continuation of the order of preventive detention. The principles have been laid down by the apex court in the case of Abdul Nasser Adam Ismail versus State of
एक
Maharashtra and
मिनट,
others. जी
ओक साहब ने मेरे को क्या बोला था, जो पुराने वाले केस में तुमने जजमेंट रेफर किया था ना, उसको रेफर मत करना, दूसरे लेकर के आओ मेरे को. तब मैंने दूसरा लेकर के आया था.
अच्छा
ये देखो.
ये वाला
हाँ,
Abdul Nasser
हाँ.
Adam Ismail. The apex court held that any unexplained delay would be a breach of constitutional imperative and it would render the continued detention of the detainee illegal. However, the apex court held that it was not necessary for the concerned authority to explain each days of delay.
ये 2013 का जजमेंट था,
Each days
लेटेस्ट
delay.
था.
हाँ
2013 का जजमेंट था ये.
ठीक है. It was held by the apex court that the explanation offered to the delay must be reasonable, indicating there was no slackness or indifference. The delay itself was not fatal, but the delay which remains unexplained, irrespective of its duration, becomes fatal for the continuation of the order of detention. The apex court observed that the length of delay is immaterial. In a given case, a longer delay can be well explained, but a shorter delay cannot be explained. Lastly, the apex court held that the court can consider whether the delay was occasioned due to permissible reasons or unavoidable causes. It will be necessary to advert to the affidavit of Shri Patil filed on behalf of the state government as well as the detaining authority. There was a composite representation made on 12th of November 2014 by the detainee, which was received by both the authorities from Nashik Road Central Prison on 17th of November 2014. On the very day, by sending a letter, Parawai's comments of the sponsoring authority were called for. As the Parawai's comments were not received, reminder letters dated 26th of... is it necessary to have at all Parawai's comments from the sponsoring authority? Is it absolutely necessary?
क्योंकि ये लोग बनाते ही नहीं है ना. डिटेंशन ऑर्डर तो वो बनाता है बैठ करके वहीं पर उनके ऑफिस में.
नहीं ठीक है, बनाता है तो कुछ तो कानून इनको नहीं, इनको भी तो कानून तो पता होगा ना. रिमाइंडर लेटर्स डेटेड 26.
जब दिमाग लगाया ही नहीं है और उनको ये मालूम है पता नहीं कौन सा एडवोकेट सामने आने वाला है और क्या हमारी उखाड़ने वाला है, तो ये लोग तो
ऐसे ही रूटीन वे में छोड़ देते हैं.
जो वहां पे नॉर्मली डिटेंशन मैटर जो डील करते हैं ना एडवोकेट्स, उनको मालूम है क्या ग्राउंड लेने वाले हैं.
Dated 10 December 2000, Parawai's comments of the sponsoring authority were belatedly received. Though on 17 November, the Parawai's comments of the sponsoring authority were called for, the Parawai's comments were received after a lapse of 23 days, along with the letter dated 10th of December 2014. There were 4 holidays on account of 4th Saturday and Sunday between 17 November and 10 December. On 12th of December, the detaining authority rejected the representation and a reply was accordingly issued on the same day. Apart from the issue of necessity of calling for Parawai's comments from the sponsoring authority, the question is whether there is any explanation for the long delay from 17th of November 2014 till 10th of December 2014 on the part of the sponsoring authority. We may note that it is not the case of the detaining authority that in the representation a reliance was placed on any material which was not forwarded by the sponsoring authority to the detaining authority for the purpose of passing the order of detention. ये भी important एक point है, बहुत important point है.
Yes. That's why I was asking कि what is the necessity of sending for comment from detaining authority? क्या मतलब हो सर? Sponsoring authority.
नया तो कुछ आने वाला नहीं है. Therefore, in this context, it will be necessary to make reference of the affidavit of Sri Madhavan, Assistant Director DRI, filed on behalf of paragraph 20, it is stated as thus. Contention pertains to the decisions taken by the received on so and so date, 12/11 or 18/11. Perusal of the said representations reveals that the conditions and all the facts were already placed before the detaining authority by way of a proposal forwarded by the sponsoring of no new facts had emerged during the intervening period. Therefore, however, Parawai's comments on the contentions raised in the representations were forwarded to the detaining authority in due course. The same was considered by the detaining authority, and as per letter 12/12/2014 received from the office of the detaining authority, is seen that the said representation was rejected. Thus, it is clear that a copy of the representation was received by the sponsoring authority on 18th of November 2014. There is absolutely no explanation forthcoming as to why the sponsoring authority took long time, up to 10th of December 2014, to submit the Parawai's comments. It took 22 days for the sponsoring authority to submit the Parawai's comments. It is not the case made out in the affidavit that the delay was due to unavoidable causes. In fact, this delay of 22 days is not even attempted to be explained, by the sponsoring authority, and therefore the contention of the delay was due to permissible reasons or unavoidable causes is not at all available to the sponsoring authority. This defense is not available. As stated earlier, even the detaining authority has not explained the delay. The delay of 22 days shows slackness on part of the sponsoring authority. Therefore, in our view, there was an unexplained delay in deciding the representations which was made to the detaining authority, which will have the effect of vitiating the continued detention of the detainee. As regards the delay in disposal of the representation made to the state government, going by what is stated in paragraph 22 of the affidavit of Sri Patil, there is an unexplained delay of 22 days on the part of the sponsoring authority in forwarding the Parawai's comments. The comments of the sponsoring authority were received on 10th of December. It is stated that the additional chief secretary home was in Nagpur for attending the winter session of Vidhan Sabha. The file was sent to Nagpur on 11th of December 2014. There were holidays on 13th. ये बोलते क्यों है सर? The order was passed on 15 December 2014. The court is not concerned with all this. 24th of December was a Sunday. However, the file was received at बहुत उपकार किया हुआ. The file was received at मंत्रालय. बहुत एहसान किया है लोग. On 23rd of December 2000, the rejection intimation was issued on 24th of December. Though learned APP is submitted, the delay was from 15th of December till 24th of December is explained by the record. There is no explanation as to why the letter of rejection was not issued from Nagpur on 15th of December itself, when the concerned authority passed the order of rejection while sitting in Nagpur. Even this delay from 15 December to 24 December is fatal. Thus, to conclude, there is an unexplained delay in deciding the representation made to the detaining authority as well as the state government, and therefore continued detention of the detainee stands vitiated. Hence, it is not necessary for us to decide the issue of validity of the impugned order of detention. Accordingly, the petition succeeds and we pass the following order. जो आप बोले थे, impugned order of detention be quashed and set aside, and the detainee be released. We direct all the concerned authorities to act upon an authenticated copy of the operative part. ये सर्वर कॉपी पे नहीं होगा. That is also an authenticated copy. बाद में सर्टिफाइड कॉपी तो बाद में मिल सकता है ना.
ये लोग क्या करते हैं, जैसे ही ऑर्डर पास करते हैं वैसे ही उसको अपलोड कर देते हैं. अपलोड करके उसका रीड बनाते हैं और सीधा का सीधा भेज देते हैं वहां पे जेल में, क्योंकि फंडामेंटल राइट है ना.
हाँ, तो वही मैं बोल रहा हूँ, सर्वर कॉपी से ही काम चल जाएगा.
हाँ, ऑथेंटिकेटेड कॉपी में चलता है. उसको ऑथेंटिकेट करता है जो बंदा इनका जो बैठा होता है ना क्लर्क, वही ऑथेंटिकेट करके जाता है, वही
ऑथेंटिकेट करके भेज देता है.
हाँ, और बाद में फिर रिट आती रहती है, जो आती है ना जिसके ऊपर वो लाल वाला स्टैम्प लगा रहता है पूरा वो अलग है, क्योंकि डिटेंशन मैटर है ना. इसीलिए तो क्या करते हैं, बिल्कुल ऑपरेटिव पार्ट पास करते हैं, बाद में डिटेल ऑर्डर बाद में पास करते रहते हो.
बिल्कुल.
आया समझ में हिरण्मय साहब? प्रैक्टिस, लोग बाग गाली देते हैं वकीलों को, कितना मुश्किल है ऐसे जजेस को झेलना। ये जो हर
अरे
बात
सर,
पे
पेपर
बकिया
वर्क
बोलना।
मैं जानता हूँ, कोर्ट का पेपर वर्क क्या होता है, मैं समझ सकता हूँ, बहुत ही
एक
झमेला
रेट
होता है।
कितना पढ़ने का होता है बोल दीजिए इनको, एक रेट कितना पढ़ने का होता है?
इसको अरे डिपेंड्स, इसमें तो मालूम है, अगर आपके पेपर हैं 1400 या 2000 पेपर है ना, पूरे पूरे जो रिलाइड अपॉन डॉक्यूमेंट देता है, उनको सबको एक
सारा
एक
देना
मिनट पढ़ना पड़ता है, तब जाके रिट बनती है।
प्लस जजमेंट्स, जो
हाँ
जजमेंट रेफर कर रहे हैं उसका दो कॉपी, उसका
हाँ,
दो
एक
कॉपी, दो
एक जज
जजेस हो
नहीं,
तो दो
दो
कॉपी।
तो दो तो
एक
सामने देना
जज को,
पड़ता है,
एक
इंडियन जज में
ऑपोजिट
तो,
को।
और सामने
अच्छा,
इसको एक वकील स्पॉन्सिंग
पब्लिक
अथॉरिटी को,
प्रोसिक्यूटर
एक
को भी,
एसीपी को,
हाँ,
जितने
रेस्पोंडेंट को भी।
जितने भी वकील बैठे होते हैं
जेरोक्स,
सबको देना पड़ता है वहां पे।
जेरोक्स का खर्चा ही कितना आ जाएगा आप सोच लो।
तुम दो
एक
जने
तो
खड़े हो रहे हो, तुम्हारे बगल में एक बैठा हुआ है, वो पढ़ता रहता है, मैं हाँ ठीक है सर, इसको थोड़ा सा जज साहब इधर देखने लग गए, जज साहब आपस में बात कर रहे हैं, अब आप तो नीचे देख रहे हो ना पढ़ने के टाइम, आपको नहीं मालूम पड़ता जजेस डिस्कस कर रहे हैं, तो फिर वो बगल वाला जो अपना साथ में बैठा होता है बताता है साहब थोड़ा रुक जाओ, वो वापस डिस्कस कर रहे हैं, या फिर सामने से वो जो कोर्ट में बैठा होता है ना पेशकार, वो बोलता है रुक जाओ, क्योंकि हमारी आंखें तो नीचे होती हैं, तो कोर्ट को देख नहीं रहे होते हैं।
परंतु सर मतलब 2018 के बाद से लेके अब तक एक मतलब किसी गवर्नमेंट ने या किसी गवर्नमेंट सरकारी ऑफिसर मतलब सरकारी तरफ से एक ऑर्डर आया था, या फिर एक क्या कहते हैं इसको, गैजेट ऑफिसर में, गैजेट में जो क्या कहते हैं नियम आता है ना, वहां पे लिखा है कि आप किसी भी कोर्ट के जज को लॉर्ड नहीं बोलेंगे, केवल सर बोलेंगे।
मैं
ये कहाँ लिखा है? ऐसा कहीं नहीं है यार,
कोई
कहीं
कोई एक
नहीं।
आदमी अहमद जज आया होगा जिसने बोला ठीक है मेरे को माय लॉर्ड मत बोलो, बाकी सबके सब माय लॉर्ड ही सुनना चाहते हो। कोई ऑर्डर नहीं आया, ऐसा कोई ऑर्डर पास ही नहीं कर सकता कोई, अंटिल सुप्रीम
ऑर्डर नहीं, कोर्ट का ऑर्डर नहीं है कि ये या तो किसी मतलब
वो
फिर
कोई
क्यों
मानेगा
किसी
स्टेट
वो
में।
क्यों मानेगा? अगर ऐसे ऑर्डर होगा तो
क्यों
कोर्ट
मानेगा
बोलेगा कि
इसको?
उसको उठा के फेंक देगा, उसको बोलेगा कंटेम्प्ट मार देगा उसके ऊपर।
मैंने पढ़ा था, मुझे याद नहीं क्योंकि
अच्छा,
वो
मैं एक बात चीज बताऊं, माय
हाँ,
लॉर्ड
बोलिए।
बोलना नहीं बोलना ज्यादा जरूरी है कि कानून जानना ज्यादा जरूरी है, ये बताइए।
नहीं, कभी कभी
अपने को कानून से
गलत
मतलब
से
है,
सर निकल जाता है ना।
नहीं नहीं, अपने को कानून से मत, नहीं, गलत से नहीं निकलेगा, नहीं निकलेगा। बल्कि एक दिक्कत ये है, लोअर कोर्ट में भी हम लोग जाते हैं तो मुंह से माय लॉर्ड निकल जाता है, और वो अगला बोलता है योर ऑनर बोलो, क्यों बोल रहे हो माय लॉर्ड? अरे इतना मुझे एलिवेट मत करो,
वो
मजाक
नीचे
करते हैं।
नीचे नीचे कोर्ट में,
हाँ, नीचे कोर्ट में मजाक नहीं करते हैं, मुंह से माय
हाँ
लॉर्ड निकलता तो
हाँ
बोलते
वो लोग
डोंट
माय लॉर्ड
एलिवेट
नहीं
मी
बोलते,
टू अ स्टैचर टू विच आई डू नॉट
ऑनर भी नहीं
बिलोंग
कहते वो लोग।
करके, लेकिन मुंह से निकल जाता है ना। ऐसा आदत हो गया कि मुंह से आगे माय लॉर्ड पीछे माय लॉर्ड, तो निकल ही जाएगा, कोई उपाय नहीं है। अब अच्छा, मैं बोलता हूँ कि माय लॉर्ड बोलो नहीं बोलो ज्यादा इम्पोर्टेंट नहीं है, इम्पोर्टेंट है कि आप किस मतलब फैक्ट्स पे और लॉ पे आप, मेनली ऑन लॉ, if the facts are correct and the law follows correctly, then only you'll win the case. तो मान लीजिए माय लॉर्ड बोलता भी हूँ तो मेरा इज्जत वहाँ थोड़ी कुछ कम हो रहा है, मैं तो वहाँ आर्ग्यू करने गया हूँ ना।
हाँ ठीक है, वो तो ठीक है, मतलब अगर मुझसे
हाँ,
अगर
तो ये
निकल जाए
छोटा
सर
मोटा
तो
चीज पे देखिए, ये सब छोटा मोटा चीज है, इस पे ध्यान आप मत दो, आपका काम है काम निकालना वहाँ,
हम्म।
आपका काम है काम निकालना, आपका
हाँ,
काम
मेरा
लड़ना नहीं है,
मतलब
वहाँ
कोई
लड़ने
भी
नहीं जा रहा हूँ मैं।
नहीं, कोई भी मतलब लॉयर का काम होता है कि पोलाइटली बोलना।
हाँ, तो हम इसीलिए सबमिशन बोलते हैं ना, हम लोग क्या बोलते हैं, लर्नेड काउंसिल और लर्नेड एडवोकेट सबमिट्स, कभी बोलता
हाँ
नहीं है कि पिटिशनर स्टेट्स बोलता है, लेकिन लर्नेड काउंसिल सबमिट्स, हमारा सबमिशन होता है, रिस्पेक्टफुल सबमिशंस। अब कोई उल्टा सीधा बोल दे, दैट इज एन एक्सेप्शन,
नहीं, गाली
लेकिन बोलना नहीं
मैं
चाहिए।
जैसे कि मैं कभी गाली देता ही नहीं, मतलब मेरा रूल है, मैं गाली देता ही नहीं। मैं आज तक गाली दिया हूँ, 27 गाली दिया हूँ।
लिख के रखता
मेरे
है,
मुंह से एक्सेप्ट।
ये लिख
हाँ,
के रखता है, गाली देता है
लिख
लिख
के
के
रखता है
रखता
किसने गाली दिया।
है।
मैंने काम किया है कि मैंने 27 बार मेरे मुंह से गाली निकल गया है।
अरे अंग्रेजी भाषा ऐसा है ना, उसमें घुमा के भी जूता मारा जा सकता है, अच्छा से भिगो के भी। उस दिन हम लोग नहीं सुन रहे थे, सुप्रीम कोर्ट में क्या हो रहा था, कैसे मेहता साहब कैसे घुमा कर बोल रहे थे,
नहीं सर, अगर
I
अगर मेरे
respectfully
साथ
with due respect to my lords, with the greatest of respect करके कैसे वो घुमा कर बोल रहे थे।
अच्छा, अगर मुझे किसी को इंटरप्ट करना है तो मैं बोलता हूँ विदाउट रिस्पेक्ट, ऐसे बोलता हूँ।
मैंने इंटरप्ट तो वहां तो ऐसे नहीं होता ना, एक के ऊपर आप कोई बोल रहा तो उसके ऊपर आप बोल नहीं सकते हो ना, वो खत्म करेगा फिर आप बोलना शुरू करो। आई क्रेव योर लॉर्डशिप्स इंडल्जेंस, आप बोलो फिर, अगर बोलना चाह रहे हो दैट दिस जेंटलमैन मिसलीडिंग, माय लर्नेड फ्रेंड
नमस्कार
देयर इज
सर, आपको
मिसलीडिंग द
डिस्टर्ब कर
कोर्ट।
रहे लगता है।
नमस्कार प्रेम जी।
प्रेम जी सत श्री अकाल।
सब बहुत
नमस्कार जी,
आपको जय काल।
नमस्कार नमस्कार।
नमस्कार जी सबको नमस्कार। कैसे हैं आप लोग?
बस सर आपका आशीर्वाद है सर, आप लोगों
सुन
का
रहा
आशीर्वाद है, चल रहा है।
बहुत बढ़िया सुन रहा था मैं आप लोगों को,
हम
बहुत अच्छा चल रहा है।
कानूनी पचड़े में फंसे हुए हैं साहब।
हाँ
नहीं
बस
ये आज का सर ये था कि कोई आदमी पकड़ा जाता तो उसका राइट्स क्या है, मतलब दो केसेस में ना, एक नॉर्मल इंडियन पिनल कोड के द्वारा यदि अरेस्ट किया जाता है, एक डिटेंशन, प्रिवेंटिव डिटेंशन, मतलब कोई गलत काम ना करे उस समय पकड़ा जाए, तो उसमें क्या क्या रिकॉर्सेस अवेलेबल हैं अंडर लॉ, वही हम लोग डिस्कस कर रहे थे।
दादा ये पढ़ो, ये भी एक वैसे ही है, 25 के ऊपर है।
आर्टिकल 25 के ऊपर।
आप पढ़िए, मैं म्यूट करता हूँ।
अनीता अजय शर्मा वर्सेस स्टेट ऑफ
ठीक है,
महाराष्ट्र।
खुला रखो ना, कौन मना कर रहा है यार।
बोलना मत।
हाँ, अनीता राज शर्मा
अनीता अजय
स्टेट ऑफ
शर्मा वर्सेस
महाराष्ट्र।
स्टेट ऑफ महाराष्ट्र।
हाँ, इसमें भी आप थे ना।
फिर यही ओक साहब का, मेनन साहब का जजमेंट है इसमें। ओक साहब ने
हाँ
क्या
हाँ,
बोला, मेनन साहब को लिखने के लिए बोला, तो मेनन साहब ने लिखा है, ही इज स्टूडेंट ऑफ डॉन बॉस्को, बॉम्बे।
अच्छा अच्छा,
हाँ
ये मेनन साहब।
हाँ, आप तो शायद रिटायर होंगे।
अच्छा,
ये डीआरआई है, डीआरआई रिस्पॉन्डेंट है इसमें।
हाँ हाँ हाँ, डायरेक्टरेट ऑफ रेवेन्यू इंटेलिजेंस।
पढ़ो इसको यहाँ पे।
दिस पिटीशन सीक्स
ये अभी
writ
देख
of
लो, ये तो हो गया, ठीक है, हमने फाइल कर दिया, उसकी वाइफ ने फाइल कर दिया। फैक्ट लीडिंग टू, ये पढ़ो क्या बोल रहा है ये।
हाँ, in on 15th of July 2013, the officers of the Directorate of Revenue Intelligence, for short DRI, seized 132.88 metric tons of red sandals from Nava Sheva, na?
हम्म
And another quantity of 18.350 metric tons of red sandals valued at 53.15 crores and rupees 7.34 crores respectively. The detainee was arrested on 4th of October 2013 under the provisions of the Customs Act and produced before the learned magistrate 8th Court, Esplanade, Mumbai, who remanded the detainee to the custody of DRI till 10th of October 2013. In the meanwhile, on or about 4th of October 2013, the detainee filed a retraction of the statement made on 3rd of October 2013. The DRI custody was extended up to 7th of October 2013. Thereafter, he was remanded to judicial custody up to 10th of October 2013, which was subsequently extended till 29th of November 2013. The learned magistrate then extended judicial custody till 6th of January 2014. Meanwhile, the bail application made by the detainee was rejected by the learned magistrate on 29th of November 2013. It appears that the DRI applied sections 467, 468, 471, 472, and 484 of the IPC in various remand applications, and eventually the detainee was granted bail on 3rd of January 2014 after being in custody for 91 days by virtue of the fact that the DRI failed to file complaint during the statutory period of 90 days. ये एक important जगह है सर, the statutory period of 90 days. On 8th of January 2014, a further statement was recorded under 108
नहीं,
Customs
मेनन
Act by
साहब
the
ने इसको
DRI.
मालूम है क्यों मेंशन किया है। एक्चुअली
जी
कस्टम केसेस में 60 डेज होता है, बट इन्होंने क्या
हाँ
बोला, इट अपीयर्स दैट डीआरआई अप्लाइड 467 आईपीसी दिस थिंग एंड दैट थिंग, वेयर
हाँ
वेयर मोर देन 7 इयर्स इज इन्वॉल्व ना, इसके लिए वो 90 डेज
हाँ,
लेके जा रहा है।
अच्छा अच्छा। For offences which entail punishment for more than 7 years, then this statutory period may be extendable to 90 days at the maximum.
That they are called as a serious crime, heinous crime हो जाते हैं ना
हाँ,
ये?
heinous offences. On 8th of January 2014, the further statement was recorded under Section 108 of the Customs Act by the DRI. The show cause notice came to be issued on 13th of January 2014, and a corrigendum dated 14th of January 2014 to the said notice was issued to the detinue. On 12th of February 2014, the DRI filed a rebuttal to the retraction statement dated 4/10/2013, and the impugned detention order. Impugned means the order under challenge came to be passed on 29th of September 2014. The detention order was executed on 25th of October 2014. The detinue has been lodged in Central Prison Nashik since. We have heard learned counsel for the parties. On behalf of the applicant, Mr. V.B. Singh, learned advocate, confined his challenge to the ground H in the petition without prejudice to various other grounds. Learned counsel submitted that the detinue had submitted a representation addressed to the detaining authority, state government, central government, and the state advisory board through the superintendent of Nashik Central Jail, which was not expeditiously considered. The learned counsel urged that the reply of the said representation of the detinue ought to have been served upon the detinue without loss of time and in any event within reasonable time. According to him, a reply to the representation ought to have been issued independently by the detaining authority and the state government, uninfluenced by the views of the advisory board. In view of the fact that the replies were not so served, he submitted that the detention would be violative of Article 22(5) of the Constitution of India.
इसके बारे में हम
The
डिस्कस
mandate
कर रहे हैं आज की डेट में 22(5) के बारे
of
में.
Article 22(5) requires no elaboration, and the detention in the circumstances would have to be tested on the anvil of expeditious and prompt consideration. In view of the fact that the learned counsel on behalf of the petitioner has urged only the said ground, we proceeded to hear the learned counsel appearing for the respondent and the DRI. On this aspect, the affidavits have been filed. Two affidavits have been filed to oppose the petition. In the affidavit of Shri Patil, Deputy Secretary, Home Department, Government of Maharashtra, dated 8th of January 2015, he has dealt with the aforesaid ground of challenge in paragraph 26. The deponent has stated that the representation, deponent means the person who is filing the affidavit. Deponent has stated that the representation made by the detinue, means the person who is detained, dated 24/11/2013, was forwarded by Nashik Road Central Prison by letter of the same date, which was received in the office of the detaining authority on 26/11/2014. Parawise comments of the sponsoring authority were called by letter dated 27/11/2014. As the contents were not received, as the comments were not received, a reminder was sent on 4th of December 2014. It is stated that in between there was a holiday on 30th 11/2014, being a Sunday. It is further stated there were holidays on 30th 11 अच्छा on a क्या बोल रहा है, further stated there were holidays on 7/12/2014, 12/12 and 13/12 on account of Sunday and second Saturday and Sunday respectively. The Parawise comments were received from the sponsoring authority on 7/12/2014, and based on these comments and the record available with the detaining authority, a reply was prepared and submitted on 17th December 2014 for consideration of and orders of the detaining authority. It came to be endorsed by the Deputy Secretary concerned on 18th of December 2014. The Principal Secretary, Appeals and Security, and the detaining authority, after due consideration of the representation and the Parawise remarks of the sponsoring authority, rejected the representation on 18th of December 2014. The rejection was conveyed on 19th of December through Nashik Road Central Prison. Thus, it is seen that the time taken from receipt of representation dated 26 November 2014 to the final rejection is 23 days. Meanwhile, the delay in forwarding Parawise comments is at least of 20 days. Apropos the representation addressed to the state government, the same was received by the state government on 26th of November 2014, and Parawise comments were called for by letter dated 27th of October 2014. Once again, a reminder had to be sent on 4th of December 2014 ही हो गए. During that period, there was a holiday on 30/11/2014 on account of Sunday. Further, there were holidays on 7th, 12th, and 13th on account of Sunday. Same चीज फिर से बोल रहा है. The Parawes comments from the sponsoring authority were received on 7/12/2014 by the letter dated 16/12/2014. We cannot help observing that the dates of receipt of representation and the date of calling of Parawes comments and sending letter for reminder are all identical to the dates mentioned in the affidavit of the detaining authority. ठीक है. It appears that the Parawes comments were sent to the additional chief secretary on 17/12/2014. Affidavit further goes on to say that the deputy secretary and additional chief secretary home were in Nagpur, apparently to attend the winter session of the Maharashtra Legislative Assembly session at Nagpur, which commenced on 11/12/2004. In view of the fact there was no possibility of the two gentlemen returning to Mumbai till the end of the assembly session, the file was sent to Nagpur on 18th of December 2014. After considering the representation of the detainee and the Parawes comments from the sponsoring authority and the chief secretary home rejected the representation on 2012/2014. The file sent from Nagpur was received by the Home Department Mumbai on 23/12/2014. The letter intimating rejection was forwarded to the detainee through the Superintendent Nashik Road Central Prison on 24/12/2014. Thus, from the facts as disclosed in the affidavit of the detaining authority, it can be seen that the representation was made on 26/11/2014 and was disposed of only on 20/12/2014 and was communicated to the detainee 4 days thereafter on 24/12/2014. On behalf of the respondent number 4, DRI in an affidavit, DRI filed an affidavit and in view of the fact that the petitioner has restricted himself to ground 7H of the petition has been dealt with in paragraph 11 of the affidavit. The representation made by the detainee was received by DRI on 28/11/2014, 2 days after the same was received by the detaining authority. Although the office of the DRI is also within the city of Mumbai. So बोल रहा 2 दिन क्यों लगा? The copies of representation were also received by the central government on 9/12/2014, calling for Parawes comments. The Parawes comments were then forwarded on 16/12, 19 days after the receipt of representation by the DRI. Further appears, मतलब 19 दिन बैठा हुआ था. It appears that on 19/12/2014, the DRI received communication from the Office of the Detaining Authority stating that the representation of the detainee was rejected by the detaining authority on 24/12/2014. This date is material, which we will shortly advert to the same, and we will shortly advert to the same. It is further stated that by communication dated 26/12/2014 from the government of Maharashtra, it was conveyed that the representation was rejected by the additional chief secretary home. No doubt, the affidavit states that the detainee was a prime member of the organized syndicate indulging in the smuggling of red sandals, a natural resource prohibited for export under the provisions of foreign trade policy and restricted as per Appendix 2 of CITES. However, it is stated that red sandals are found only in India, and safeguarding these endangered species is the obligation of the state. While we can appreciate the importance of protecting the endangered species like red sandal, and the same needs to be approached with great amount of zeal, the answer does not be in the preventive detention per se. Steps to be taken pursuant to such detention must be taken promptly. In the instant case, the time taken to decide the representation of the detainee is not justifiable, especially in the light of various pronouncements of the Honorable Apex Court. The case of Harish Pava versus State of UP, AIR 1981 SC,
पढ़ लिया तो
cited another judgment, Raj Ammal versus State of Tamil Nadu.
ये रामाधंदु बाद में
फिर
वो भी हो गया.
Bora Day, no?
हाँ.
True, there is
Nagpur
no
Test.
prescribed period. In case the gap between the receipt of the representation and its consideration by the authority is so unreasonably long and the explanation offered by the state authority is so unsatisfactory, such delay could vitiate the order of detention. It is to be noted that Article 22(5) enjoins upon the state to satisfy the constitutional requirement, but if this constitutional imperative is observed in the breach, it would amount to negation of the constitutional obligation, thereby rendering continued detention impermissible. The Supreme Court highlighted the fact that the representation should be expeditiously decided with due promptitude and without avoidable delay. Having considered the facts of the present case and having applied the tests laid down by the Supreme Court in the aforesaid pronouncements, the response of the concerned respondents is unacceptable. The manner in which the representation of the detainee was dealt with does not, in our view, comply with the constitutional mandate and falls foul of the obligation to decide the representation as soon as may be in Article 22(5) of the Constitution. In our view, the representation could have been decided much earlier. The duration of time that has lapsed between the receipt of representation and consideration by the authority and communication of the order of detention, as stated above, the delays of 23 days and 19 days respectively. We have noticed that in many cases, holidays are cited as reasons for delay. This has become routine. What has been lost sight of is the fact that the detainee continues to be incarcerated without trial even on holidays. The mere fact that 4 holidays intervened still does not justify the delay in considering and communicating the decisions on the representation. It is indeed the mandate of the Supreme Court. If indeed the mandate of the Supreme Court is to be honestly carried out by the authority should endeavor to prepare themselves to deal with such representation more expeditiously in the interest of upholding the law. Applying the law as laid down by the Honorable Supreme Court, the delay of 23 days and 19 days is not adequately explained. The delay, in our view, is unreasonable and does not pass the tests laid down by the Apex Court. What we find surprising is that it is the stated case of the respondent number 1 that the decision on the representation was taken on 20th of December 2014 and that it was communicated after 21st of December 2014. Since 21st December being Sunday, the file is said to have received from Nagpur in Mumbai on 23rd of December 2014, after which the rejection intimation was sent to Nasik Road Central Prison. If that be so, we wonder how in the affidavit on behalf of the DRI, it is stated in paragraph 11 that it received a communication from the Office of the Detaining Authority to the effect that the representation made by the detainee was rejected by the detaining
ये पकड़
authority.
के मैंने ही लाया था।
हाँ,
ये वो बोल रहा है 23 तारीख को रिजेक्ट किया है।
हाँ,
उनको कैसे
19
मालूम
तारीख
पड़ा
को
रिजेक्ट हो गया?
19 तारीख बता रहा है.
हाँ,
Surely there's more than that meets the eye, since admittedly the additional chief secretary had
अब
rejected the
कोर्ट
representation
इज
in
डिप्लोमेटिक। मैंने क्या बोला?
2012-2014.
ऑर्डर यही बनाते हैं
There is
और
no
यही नॉर्म बनाते हैं।
explanation.
हाँ,
There is no explanation on how communication of the said decision could have been received by the DRI in 1912-2014. जब rejection ही 20 तारीख को हुआ है,
हाँ,
we are therefore convinced beyond all reasonable doubt that the delay is not properly explained and the continued detention of the detainee is in violation of the constitutional mandate of Article 22(5) of the Constitution of India, and the order of the detention stands vitiated. The petition must therefore succeed. In the result, we pass the following order. Rule is made absolute in terms of prayer clause A and B, which read thus: order set aside, quashed and set aside, and the detainee be released forthwith.
बहुत हो गया। अभी और भी है मेरे पास, लेकिन बात इतना बहुत है। देख लिया हिरण्मय साहब?
अरे सर साहब, मुझे साहब क्यों बोलते हैं सर? मैं कौन सा साहब हूँ?
दादा,
अरे बोल,
ये पटिशन नोट कर लो, हाई कोर्ट के जजमेंट अगर कभी तुम्हारे को काम आएंगे ये।
जी
अच्छा,
जी,
ठीक
कौन
है,
सा वाला? ये अभी जो दिखा है ना?
नहीं, जितने मैं बोल रहा हूँ इनका मैं भेजता हूँ आपको, लिंक भेजता हूँ,
जी सर।
1 मिनट। नंबर भेज रहा हूँ, लिंक नहीं, नंबर उससे गड़बड़ हो रहा है, वो नहीं आ रहा है वो।
हाँ जी, हाँ जी, कोई
ये
कोई
पहला
दिक्कत
जजमेंट है, नोट कर लो इसको।
नहीं। जी
देन जादव वाला जजमेंट है।
ये कहाँ पे भेजना सर? ये व्हाट्सएप पे?
नहीं नहीं, ये प्राइवेट चैट में।
अच्छा, ठीक है, ठीक है, ठीक है, ठीक है। हाँ ठीक है सर।
तो उन्होंने केस नंबर भेजा है, केस नंबर।
हाँ हाँ हाँ, उससे वो मिल
वो
जाएगा,
ढूंढ लेंगे,
उससे
वो
मिल
वकील है
जाएगा।
वो।
वो मैं जानता हूँ, निकाल दूंगा मैं, कोई दिक्कत नहीं।
ये जोशी वाला है, दूसरा वाला जजमेंट
जी
4411
जी
वाला।
जी जी
ये अजय शर्मा वाला है,
जी
4618।
हाँ जी। और भी कुछ भेज रहे हैं क्या सर?
एक और है अभी।
जी जी
ये कमलेश पुरोहित का है, ये आया।
जी।
ये सारे एसी पे है, 22/5 पे है।
हाँ ठीक है सर। नहीं, ये काम देगा, डीआरआई का ये सबका केस आने से काम तो देगा ये। और वैसे भी जानना जरूरी है।
डिटेंशन मैटर कहाँ पब्लिक को ज्यादा मालूम है यार, समस्या तो ये होती है। उसमें तो बहुत कुछ पढ़ना पड़ता है, आपको रिलेवेंट एक्ट भी पढ़ने पड़ेंगे, वो भी पढ़ना पड़ेगा, क्या क्या होता है।
जी जी जी।
सो हिरणमय कैसा रहा, मजा आया क्या?
परंतु मैंने वो आर्टिकल नंबर गलत बोल दिया। मैंने बहुत मतलब महीनों पहले पढ़ा था, तो इसलिए थोड़ा गलत बोल दिया।
कौन सा आर्टिकल?
वो आर्टिकल 22 मैंने गलत बोल दिया। एक और आर्टिकल है ना, जो बोलता है कि एक ही सजा के लिए दो बार, एक ही अपराध के लिए 2 बार सजा नहीं हो सकती। वो
वो
है
20 है,
इसी
आर्टिकल
में है।
20 है वो।
हाँ, वो वाला मैंने गलती से ये वाला मैं बोल दिया। मैंने पढ़ा था, इस आसपास ही होगा, इसलिए गलती हो गई।
आज स्ट्रीम हमारी तो उसी के ऊपर हुई थी ना।
जी जी। जजमेंट सारा मैं नोट कर लिया हूँ। निकाल लूंगा रात को।
ये लास्ट वाला जजमेंट है ना गवाही साहब का।
जी जी।
अच्छा, ये जो अपने जजमेंट भेजे हैं, ये सबके सब क्या मुंबई हाई कोर्ट के हैं?
अरे भाई मैं वहीं
ये तो
प्रैक्टिस
शर्त
करता
है
हूँ।
ना, इसमें शर्त है।
ये मेरे हैं।
वही तो, मतलब कोई ऐसा वेबसाइट होना चाहिए जहाँ पे केस कोई भी हो, किसी भी कोर्ट में हो, मतलब हाई कोर्ट या सेशन कोर्ट या फिर सिविल कोर्ट पे हो, वो मतलब ये मतलब अगर कुछ सर्च करे तो मिल जाना चाहिए, मतलब सिंगल वेबसाइट होना चाहिए।
ये दूसरे तरीके का जजमेंट है, इसमें डिले इन पासिंग ऑर्डर की बात कर रहे हो।
जी
डिलेइंग पासिंग ऑर्डर, एक एक कहते हैं ना कि जस्टिस डिले जस्टिस डिनाइड,
कमलेश
ऐसा कुछ
प्रेम
कहा होगा।
शंकर पुरोहित।
सन ऑफ प्रेम शंकर पुरोहित, प्रेजेंटली इन नासिक प्रिजन। ये जादव के साथ गया था अंदर,
जी।
जिधर को जस्टिस बी आर गवई, गडकरी 26
एस
मार्च।
गडकरी। APP with much vehemence opposed. देखिए, delay have been explained in the affidavit.
मैंने ये बोला ना उसको, इसीलिए कह रहा ना वो, देखो यहाँ पे
Inordinate
बोला।
delay in passing the order from the date of seizure. Impugned order suffers from non-application of mind and is liable to be quashed and set aside. वो बोल रहा delay has been properly explained. APP बोल रहा है.
He purchased
Explanation given by the
he
sponsoring
purchased
authority and the detaining authority are sufficient.
we find though the petition has raised several ground and that पढ़ो
Ground of delay. As such, it is we find that though the petitioner has raised several grounds in support of the petition deserves to be allowed on short ground of delay. As such, it is not necessary for us to go into the into the rival contentions insofar as other grounds are concerned. The petitioner has raised ground regarding delay in ground B of the petition. It would be appropriate to consider the explanation given by the sponsoring authority in this affidavit in replying the said ground. It reads as under. वही रेड सैंडर्स का है, वही है।
नहीं छोड़ दो उसको, ये पढ़ो।
T.A. Abdul Rahman versus State of Kerala. No hard and fast rule can be precisely formulated that would be applicable under all circumstances, and no exhaustive guidelines can be laid down in that behalf. It follows that the test of proximity is not a rigid and mechanical test by merely counting the number of
days.
Counting the number of days, months between the offending acts and the order of detention. However, when there is undue and long delay between the prejudicial activities and the passing of detention order, the court has to scrutinize whether the detaining authority has satisfactorily examined such a delay and afforded a tenable and reasonable explanation as to why such a delay has occasioned. When called upon to answer and further, the court has to investigate whether the causal connection has been broken in the circumstances of each case. Similarly, when there is unsatisfactory and unexplained delay between the date of the order of detention and the date of securing the arrest of a detainee, such a delay would throw considerable doubt on the genuineness of the subjective satisfaction of the detaining authority, leading to a legitimate inference that the detaining authority was not really and genuinely satisfied as regards the necessity for detaining the detainee with a view to preventing him from acting in a prejudicial manner. वही सेम चीज बता रहा है, नीचे एपेक्स कोर्ट का वही चीज बता रहा है. No explanation was given. In the present case, we find there is not much delay at the level of the detaining authority. The detaining authority has given details as to the various steps taken by it between the receipt of the proposal till the passing of the order. And so far as the contention of the sponsoring authority and the delay occasions in the matter was being investigated is concerned, it will be relevant to refer to the observations of the Apex Court in the case of Isaac Babu versus Union of India.
ये शोकाज
Isaac
की
Babu.
बात कर रहे हो। ये पढ़ो, we do not think.
After investigation, acha, we do not think this is a satisfactory explanation. It was not incumbent on the authorities to wait till the issue of the show cause notice. The need to issue a show cause notice within 6 months has nothing to do with the processing of the detention papers. Now, therefore, this explanation is far from satisfactory. It can be seen that in the aforesaid case, a ground was sought to be raised that the matter was being investigated and a show cause notice was issued to the petitioner therein. However, the Apex Court has held that the said explanation was not satisfactory. It has been held by the Apex Court that it was not incumbent on the authorities to wait till the issue of the show cause notice. As observed here in above, it can be seen that there is a gap of almost 1 year, 5 months, and 9 days from the date on which the seizure was effected and the proposal was sent to the sponsoring authority by the sponsoring authority to the detaining authority. The gap between the seizure and the order of the detaining authority is 1 year, 8 months, and 16 days. It can thus be seen that the live link between the alleged prejudicial activities of the detainee and the actual detention of the detainee has been snapped. It cannot be said that the purpose for which the detention order has been passed has a proximate nexus with the alleged prejudicial activities of the detainee. We further find that subjective satisfaction of the detaining authority would also prejudicially be affected on account of inordinate and unexplained delay. Firstly, because of date of the alleged prejudicial activities and the date of sending the proposal, and secondly, the date of alleged prejudicial activities and the date of actual detention of the detainee. We therefore find that the impugned order is not sustainable in law. We quash and set aside the impugned detention order. The detainee is directed to be released forthwith. The rule is made absolute accordingly.
चलो ठीक है, कल सवेरे कोर्ट जाना होगा ना, बंद करते हैं।
हाँ, जाना तो है ही सर।
चलो बंद करते हैं, राइट।
ठीक है सर, नमस्कार।
हाँ, जिसको लाइक करना है लाइक कर लेना भाई, शेयर कर देना अगर अच्छा लगे तो।
जी
कम से कम हिरणमय जैसे जो स्टूडेंट्स हैं उनको तो जरूरत है इन चीजों को पढ़ने की और शेयर करने की। बाकी जो एक्स मुस्लिम चैनल में जाकर के मोहम्मद साहब की बीबी के बारे में बात करते हैं, 9-5 के बारे में बात करते हैं, उनकी बात नहीं कर रहा हूँ।
ठीक है,
गुड नाइट, बंद करो।
गुड नाइट सर, कल मिलते हैं।